Taylor Calcara on behalf of Sunflower Electric Power Corporation.
Morning, Taylor. And for KCC staff.
Good morning, Commission. Carly Massentine on behalf of KCC staff.
Okay. Good morning, Carly. Does staff have a recommendation regarding
Taylor
notice?
Calcara on behalf of Sunflower Electric Power Corporation.
Morning, Taylor. And for KCC staff.
Good morning, Commission. Carly Massentine on behalf of KCC staff.
Okay. Good morning, Carly. Does staff have a recommendation? And for KCC staff. We are
Morning,
off the
Commission.
record.
Yeah. Okay. Like as you're falling to sleep on loop.
I was contemplating this last year. Sure.
All right. We are back on the record in this proceeding. I believe we left off after the entries of appearance, and I have requested that staff give a recommendation regarding notice of this proceeding this morning.
Yes, thank you. Based upon the issuance of a procedural schedule in this matter on June 11th, 2024, which set the hearing to begin at this date and time and was served upon all of the parties, staff recommends a finding that notice was proper.
Are there any objections? Hearing none, I will find that notice is proper and the commission has jurisdiction to hear this proceeding at this time and place. We'll now start with some preliminary matters. Mr. Schulte, I understand first that you wanted to address the status of the Greenbelt alternative route. And I know there was a joint motion for a settlement filed on Friday. If you could just describe the status of that.
Certainly, thank you. So yes, on Friday, the Grainbelt Express and the Boyd interveners filed a settlement that resolved the issue for the purpose of this case for the portion of the Meade to Dodge City line that impacts the Boyd's property. It is a section of slightly less than 5 miles that could be avoided if the Boyd Alternative 2 were to be adopted. Boyd Alternative 2 is one of 3 alternative routes that were entered into the record of this proceeding at various times. And there was a Boyd Alternative 1 that was recommended by Mr. Boyd in his direct testimony. Then there was a Grainbelt alternative that was suggested as a possibility by Grainbelt in their rebuttal testimony. Since that time, there's been further discussions, and Boyd Alternative 1, both Boyd Alternative 1 and the Grainbelt alternative have been taken off the table because those were not desirable by either party for different reasons. So the issue came down to Boyd Alternative 2 or the proposed route. And the settlement that has been submitted for your consideration is would carve out that section of the route for further analysis in a filing early in 2025, and then a procedural schedule that would follow from that. That would give the opportunity for landowners that are impacted by Boyd Alternative 2 who did not receive notice of the proposed route. They would receive notice, they would receive due process. Mm-hmm. We would come back to the commission, and the commission would make a decision on the final piece of the Meade to Dodge City line.
Okay, appreciate the update. Any questions from the other commissioners on the status? Okay. Let's move on. I do also understand we have a good number of pre-filed testimonies already filed in this docket, and I understand the parties may want to go ahead and just admit those via a motion. Is that correct, Ms. Mazzantine?
Yes, staff would move to admit all of the pre-filed testimony, and for the purposes of the evidentiary record, I'm going to just read through the list of that. So bear with me here. Staff moves to admit the following into the evidentiary record. the direct testimony filed by applicants on May 31st, 2024, the direct testimony of staff and interveners filed on July 3rd, 2024, the direct testimony filed by applicant on July 9th, 2024, the affidavit of publication and notice to landowners by Emily Highland filed July 9th, 2024, the affidavit of notice to landowners by Karen Cash filed July 9th, 2024, the rebuttal testimony filed by applicant on July 26th, 2024, the testimony in response to public comments filed by applicant on August 2nd, 2024, the direct testimony of Paul Owings on August 7th, 2024, the affidavit of publication and notice to landowners by Emily Highland filed August 8th, 2024, the rebuttal testimony of applicant in response to staff on August 14th, 2024, the Boyd's supplemental testimony filed August 15th, 2024, and staff's response to the supplemental testimony of Bradley B. Boyd filed August 21st, 2024.
All right. Are there any objections or corrections to that list of testimonies? Hearing no objection to the motion, I will admit all of that referenced testimony and documents into the record.
And Chair, if you would, staff has one further preliminary matter.
Sure.
Chair French, sorry to interrupt. I wanted to make sure that the testimony, the direct testimony of Jamie Prech that was admitted to the record included the supplement that was later filed. I don't have the date in front of me. I can pull it up. But just to make sure that the record is complete, I wanted to flag that.
Could you find the date of that for
Yes, I
us
will.
real quick?
It was July 9th, 2024. The direct testimony of Jamie Prech and exhibits thereto were updated to include missing pages.
Oh, okay. Any objection to making the clarification that the motion includes that? That document will also be admitted into the record.
Thank you.
And finally, one item that I had noted.
Sorry.
Oh, go ahead, Carly.
Staff had one final preliminary. Staff further moves that the commission allow it to make a correction to the title of the August 7th, 2024 testimony filed by Paul Owings. Staff initially filed this as direct testimony, but in order to avoid confusion with the direct testimony that was filed July 3rd, 2024, staff respectfully requests to relabel its August 7th, 2024 testimony for the record as Paul Owings' testimony in response to public comments.
Any objection? Hearing none, I will grant that motion. The other item that I had is with consideration of the settlement that was filed on Friday. By my count, we are down to one disputed issue among the parties, at least. I understand there's an opportunity for the commissioners to ask questions of any witnesses, but I am curious. I see we have a good number of Greenbelt witnesses listed as available today. Have the parties had any discussions about whether all of the witnesses listed as available will be needed for examination today?
We've only been able to have very preliminary discussions, but I do think we need, I would think it would be helpful to poll the parties at this time to see.
Do you know which people you want? Let's just briefly run through Greenbelt's witnesses. and see if the parties have questions for them. I do understand commissioners will probably have questions for Mr. Chandler, so he's not dismissed. Jamie, is it Prech? Any questions for that witness? Seeing none. David Gelder.
Mr. Commissioner, Sunflower has a few questions for Mr. Gelder. Sunflower Electric Power Corporation. Taylor Calcara. Hopefully it doesn't repeat it.
All right, so Mr. Gelder is not dismissed. Carlos Rodriguez, any questions for Mr. Rodriguez? Mr. Sakura?
Yes, we'll have some questions on the SPP study.
Likewise, Sunflower Electric has questions for Mr. Rodriguez.
For Emily Highland. Okay, Ms. Highland will not need to appear. For Brad Fine. All right, Mr. Fine will not need to appear. And given the settlement filed on Friday, will anyone have questions for Mr. Boyd, or will any commissioners have questions for Mr. Boyd? All right, Mr. Boyd, you will not have to take the stand. All right, and we will leave Mr. Tamimi and Mr. Owings on the list. So that gets us on our way. Thank you for indulging me. Are there any other preliminary matters the parties want to address before we move forward? Okay, hearing none, we will move to the procedure for this hearing. I understand that the parties do wish to make opening statements. I will have Greenbelt go first, followed in order by the Boyds, then NG, then Sunflower, and then staff. After opening statements, we will follow the order of witnesses agreed to in the pre-hearing conference. And I understand that at the pre-hearing conference, the parties indicated they will not make closing statements, and that we will have a procedural schedule with post-hearing briefs. So with that, we will turn to our opening statements, and Greenbelt, you may begin.
Thank you, Chair French. We did have a PowerPoint presentation that was emailed to IT. I'm not sure if we can get that up.
Wait just a moment. There we go.
Okay. And then is the best thing to do just to ask to advance the slides orally?
Here it is.
Thank you very much. That worked very smoothly. Good morning again, Commissioners. On behalf of Greenbelt Express, thank you for consideration of the line siding application today, which requests siding permits for two interrelated transmission lines, the Buckland Dodge City line and the Meade Dodge City line. Both of them are considered AC collector lines that constitute part of the AC collector system, which was part of the CCN, the Certificate of Convenience and Necessity, that was issued to the Greenbelt Express project as a whole in 2011. These are high-level maps that show the approximate route, the approximate proposed route of the two lines. On the right is the Buckland Dodge City line, which is approximately 16 miles. On the left is the Meade Dodge City line, which is approximately 46 miles. Because of the different mileage, these two maps are not to scale, but they do have a common endpoint on the north end of the line, which is the switchyard, the AC switchyard, which will be on the property that is also occupied by the HVDC converter station, which will then convert the power to direct current for transmission across the Greenbelt Express HVDC project as a whole. And while we're able to save some time in this evidentiary hearing due to the agreements that have been reached, I can assure you that the process to get here was anything but abbreviated. The routing process that was undertaken by Grainbelt was detailed and thorough, and it included extensive feedback from landowners. The process began almost or over a year ago when Grainbelt Express engaged Burns & McDonnell as its routing consultant. The process began by selecting study areas for the two lines and gathering data on the study areas to determine constraints and opportunities. That resulted in an alternative route network that is pictured on the screen now. These alternative route networks were shared with landowners along the alternative route networks, and landowners were invited to a series of 6 open houses hosted by Grainbelt between February 27th and February 29th, 2024. The open houses were held in Ford, Gray, and Meade counties, and there were a total of 140 open house participants. That feedback was incorporated into the routing study, and on May 31st, 2024, Grainbelt Express filed its line siting application with the commission. So in addition to the 6 open houses and 140 open house participants in February, there have been 22 pieces of testimony filed in this proceeding by 9 different witnesses. There was also a local public hearing conducted by the commission on July 10th, 2024. That local public hearing was preceded by an open house and a question and answer session. There were many participants in those sessions, and then during the official part of the local public hearing, there were 15 comments received. There were 13 additional comments received by the KCC through letter, phone, email, and website. The commission is required to make its decision with respect to the necessity for and the reasonableness of the location of the proposed electric transmission lines, taking into consideration the benefit to both consumers in Kansas and outside of Kansas and the economic development benefits in Kansas. No party in this case has contested the necessity for the proposed AC collector lines, and save for the bifurcated section that we discussed earlier, no party is contesting the reasonableness of the location of the AC collector lines. Accordingly, Grainbelt Express has satisfied these statutory requirements. However, the statute does go on to read that the commission shall issue or withhold the permit applied for and may condition such permit as the commission may deem just and reasonable, and may, in its judgment, best protect the rights of all interested parties and those of the general public. Commission staff, through its direct testimony and in response to public comments, recommended several conditions be included with the siting permit. With a few clarifications, Grainbelt Express agreed to those conditions, and the agreement is set forth in the joint list of disputed and resolved issues, which was filed on August 19th. I've listed those conditions on the screen. I will save you from me reading through each of them, but a few highlights include a master plan to be filed at least 90 days prior to the next AC collector line siting application. It includes a requirement to provide copies of SPP studies related to the interconnection of Grainbelt Express with the SPP electric grid. It requires Grainbelt to not install transmission facilities on easement property until it has executed interconnection agreements with the generators that will be using those AC collector systems or AC collector lines. If the project is not built, Greenbelt Express must return easements to landowners. And Greenbelt Express will contact landowners to determine height of agricultural equipment to ensure that the minimum line clearances are adequate for the large agricultural equipment used in the area. In addition, it should be noted that Greenbelt Express has filed additional landowner protections in the form of landowner protocols, code of conduct, and an agricultural impact mitigation protocol. Those were attached to the testimony, I believe it was the rebuttal testimony in response to public comments filed by Brad Fine. Those landowner protections satisfy the statutory requirement in KSA 66(1,183), which requires every electric utility which constructs a transmission line to restore the land to the condition that existed prior to construction. The landowner protocols, code of conduct, and agricultural impact mitigation protocols go much further than that, however, and also formalize Greenbelt's commitment to treating landowners with respect, providing clear communication, their approach to negotiating voluntary easement agreements, and more. With respect to routing, as we discussed, the only remaining issue was resolved on Friday when Greenbelt and the Boyd interveners finalized a settlement agreement that proposes to bifurcate an approximately 5-mile section of the Meade Dodge City line for further procedure and analysis. On this slide, the Boyd Alternative 2 is depicted in green. The proposed route is depicted in pink, and the Boyd Alternative 1 is depicted in blue, although the Boyd Alternative 1 is no longer under consideration. Although Greenbelt believes that the relevant section of the proposed route in pink is consistent with the routing principles established in the routing study, Boyd Alternative 2 was identified by the Boyd interveners as its preferred alternative in public comment submitted on July 13th and subsequent supplemental testimony by Mr. Boyd filed on August 15th. In supplemental testimony filed by staff, in supplemental testimony filed by staff on August 21st, staff stated that the proposed route is reasonable, but the Boyd Alternative 2 may also be reasonable. However, public notification and public meetings would be required to determine if Boyd Alternative 2 is reasonable. The Boyd interveners list of contested issues also asked the commission to consider, quote, deferring a decision on the transmission route across the properties owned by the Boyd interveners and ordering a second public hearing. It was along those lines that formed the basis of the settlement that was filed on Friday. Under the settlement agreement, Greenbelt Express will develop a routing analysis comparing the Boyd Alternative 2 and the portion of the proposed route for the Meade Dodge City line that would be avoided if the Boyd Alternative 2 is used. The routing analysis will be filed by January 31st, 2025. Greenbelt Express, the Boyd interveners, and staff will coordinate on a procedural schedule, which will include a local public hearing pursuant to the citing statute to give the landowners along the Boyd Alternative 2 a chance to comment on that alternative. Of course, the landowners along the proposed route will also be invited to that local public hearing. The commission will then decide which of the two routes is the most reasonable, and the parties agree not to contest the commission's determination of the ultimate route. The parties also agree that this limited settlement does not delay or otherwise impact the finality of the order granting a siting permit for the proposed route for the Buckland Dodge City line, which no one has contested the reasonableness of the location for that line. Nor would it delay the finality of the order on the remaining portion of the proposed route for the Meade Dodge City line. Staff has stated that they're not opposed to the settlement agreement. The other parties were informed of the settlement agreement before it was filed, but only shortly before it was filed, and have not had enough time to state their positions. But hopefully that will be part of the process today, is to learn whether anybody has opposition to the settlement agreement. In light of the settlement agreement between Grainbelt and the Boyds, there's only one remaining issue, as alluded to by Chair French. That is between Grainbelt and Sunflower. As you'll recall, Grainbelt has already agreed as one of the conditions with staff to provide the commission with copies of SPP studies related to the interconnection of Grainbelt Express with the SPP electric grid. The studies that will be filed with the commission are conducted by the Transmission Working Group at the Southwest Power Pool, also called the TWG. The TWG consists of stakeholders, including Sunflower, and as a party that will be impacted by the Grainbelt interconnections, Sunflower is involved in determining the scope for those studies and can review the results of those studies. Nevertheless, Sunflower is asking for Grainbelt to pay for additional studies to be commissioned by Sunflower outside of the SPP process. Because Sunflower has not shown that the SPP process is inadequate, we ask the commission to deny this request. Furthermore, we believe the request is discriminatory, as no other party interconnecting to SPP grid in Kansas is required to pay for additional studies outside of the SPP process. With that, I will stand for any questions from the commission about the settlement agreement, about any of the conditions or otherwise.
All right, thank you. I don't think we have any questions at this time, so we will move to counsel for the Boyds. Mr. Flaherty, do you have an opening statement?
I do. Hey, Andrew, could you hand me that clicker?
You're gonna have to speak up really loud.
Okay, can you hear me now? Great, thanks.
We can hear you, and do we have the Boyd's PowerPoint, Michelle?
Would the commission like, I did not have an opportunity to print copies of my opening statement. Would the commission like copies of that if we can get them?
I know I have it in PDF form, so I'm okay. We have them available to print.
Okay,
We're okay.
thank you.
Yeah.
Do you want it to be in an exhibit for the court reporter and to attach it, or just?
We're happy to make it an exhibit or not. There's nothing in there that's not already in the record, but
It's your call, just if you want it or not. Presently, it's not, so.
I don't think it needs to be an exhibit.
Okay.
Thank you.
All right, Mr. Flaherty, go ahead.
Good morning, Commission.
Morning.
And you should have a copy of the 4-page PowerPoint presentation that we're going to use in our opening statement this morning. Let me start off by saying it may seem a bit strange to you because I usually appear before you representing the public utility, but when the Boyd family attorney contacted me about 2 months ago and asked if I could help them in this matter, and she told me, and by the way, this is in Mr. Boyd's pre-filed testimony, how this family's farm had been in their family since 1884, how when Mr. Boyd's great-grandfather, Billy Merkel, claimed his homestead on the banks of Crooked Creek, and how the first 2 generations who had made their home on that land have died, and how members of the 3rd, 4th, 5th, and 6th generations currently make their home on this farm. I could feel the passion this family has for their home, and so I agreed to see if I could help them through this process. One of the first things I told the Boyd family attorney when she asked me about how this transmission routing process would work was that it had been my experience in representing the Empire District Electric Company in a transmission sighting case in southeast Kansas back in the late 1980s, and more recently assisting Prairie Wind Transmission Company and Grid Alliance in their certificate and transmission sighting cases, that out of all the duties given to this commission, this is the one that the commission likes the least. And that is because they know while it is important that new transmission lines are sited and built in Kansas, they also know that their decision's going to result in some landowners having to make sacrifices for the good of the public. I told the Boyd family attorney that because it is the least popular thing that the commissioners have to do, that they take it very seriously. And if there's a route that will work and will be less intrusive on those landowners who are making the sacrifice, the commissioners will attempt to find that route. Finally, I told her that you all would appreciate the passion that the Boyd's family have for their family farm, like I did. And to the extent that you could, you would take that into account in making your decision. Michelle, could you turn that to the next slide, please? Thank you. So this slide sets forth the main issue as it relates to the Meade Dodge City transmission siting application in regards to how the transmission line will cross the properties owned by the Boyd interveners. The Boyds are asking you to consider an alternative route than the original route proposed by Grain Belt in this case. It is important to note that the Boyds aren't attempting to totally shift the burden of this transmission line onto its neighbors. The Boyd Alternative Route 2, which is what the Boyd's alternative transmission route is referred to in this case, will still run across a large portion of the Boyd family farm. The Boyds will still be sacrificing for the good of the public. However, the Boyds' proposed route will be less intrusive than the original route proposed by Grain Belt. If you approve the settlement reached between Grain Belt and the Boyd interveners, it will effectively, as Mr. Schulte indicated, would carve out that portion of the Meade Dodge City transmission line that crosses the properties owned by the Boyds from this case and place it in a separate case so the parties can gather more information about the alternative route proposed by the Boyds and present that additional information to the commission. The settlement will allow the commission to make its decision on all but a few miles of the 46-mile Meade Dodge City transmission line within the time constraints under the siting statute, and will allow the commission the ability to obtain all information on the route crossing the properties owned by the Boyds in that separate case. As pointed out by staff witness Mr. Owens, the commission has done this before in prior transmission siting cases, Mr. Owens citing the more recent ITC order in which that occurred. I also think it's important to point out that in improving the settlement and the agreement reached by Grain Belt and the Boyds, that will provide more time so the commission will have all of the information before making the decision on the route that crosses the Boyds' property, that you will not be wasting your time in approving this settlement. And I say that because the record in the existing docket already shows that there is substantial competent evidence in this record to support the request made in the settlement. The pre-filed testimony that's already been filed shows that the Boyd Alternative Route Number 2 meets many of the routing principles used by Ms. Prech in her routing study, and in some cases does even a much better job in meeting the principles than the original route proposed by Grain Belt. The commission staff's expert, Mr. Owens, testifies in his pre-filed testimony that the Boyd Alternative Route 2 has merit and that there is a basis where the commission could, as what's being done in the settlement, carve out the portion of the Meade Dodge City line that runs across the Boyd's property out of this case, and the commission scheduling a second hearing to obtain additional input regarding that alternative route like it has done in other transmission cases. Mr. Owens testifies that the additional time to provide additional notice to a few more landowners that did not receive notice, in this case because they were further than the 1,000 feet from the original proposed line, and to schedule a significant or a second hearing is not significant when compared with the amount of time that has already been spent with regards to bringing this project to fruition. And I would add that scheduling a second hearing is certainly warranted, given the fact that we already are asking the Boyds to make a material sacrifice for the public interest on land that's been in their family since 1884. Michelle, can you turn on the next slide, please? This slide is a copy of Mr. Owens' exhibit PCO-3 that's included in his August 7th, 2024 testimony that's been placed in the record. The red line shown on his exhibit is the original route proposed by Grain Belt. The Boyd Farm is located on both sides of a large portion of the red line shown in Mr. Owens' exhibit. The blue line shown on Mr. Owens' exhibit is the Boyd alternative route number 2. As with the red line, a large portion of the blue line is also located on the Boyd's farm, but on the edge of their farm. It runs north along Road 16 and then turns east on JJ Road. There are a few landowners located near the blue line who will need to receive notice and given an opportunity to weigh in on this matter in a second hearing. And as pointed out by Mr. Owens, this has been done in previous transmission siting cases. But it is also important to point out that a large portion of the blue line will be on the Boyd farm, so the Boyds will be making the sacrifice for the public. I previously mentioned that in some cases, the route shown as the blue line in Mr. Owens' exhibit better meets the principles used by Ms. Prech in her route study than the Grain Belt original line shown in red on Mr. Owens' exhibit shown on the overhead. For example, one of the primary principles of routing a transmission line set forth by Ms. Prech is, to the extent possible, maximize the distance of the transmission line from residents. If you look at Mr. Owens' exhibit shown on the overhead, and this is pointed out in Mr. Owens' testimony filed on August 7th, 2024, Grain Belt's red line passes very close to 8 residences, while the Boyd's alternative route number 2 transmission line, shown in blue, runs by only 2 residences. And the evidence in the record in this case shows that one of those residents is greater than 600 feet from the blue line, and the line will not be located on that person's property. It will be located on the Boyd's property. And the other address location at the northwest corner of 16 Road and JJ Road is owned by a person who lives in Denver and does not live on the property. Testimony in this record from staff's expert, Mr. Owens, indicated that the Boyd's blue line also will provide Grain Belt with more options with respect to crossing Crooked Creek on the Boyd properties and meeting any requirements of the Kansas Department of Wildlife and Parks in crossing that creek. Michelle, you can turn on the next slide, please. This is a copy of Mr. Owens' exhibit PCO-4. This is also a photo of the Boyd's property. Mr. Owens shows that both Grain Belt's red line and the Boyd alternative blue line have to cross Crooked Creek on the Boyd's property. The testimony from Mr. Owens is that crossing Crooked Creek using the Boyd's blue line location provides Grain Belt perhaps better, certainly more options than crossing Crooked Creek using the location of Grain Belt's red line. Let me give you just one more example that is already in the current record. And Michelle, if you could turn back to slide 3. Yeah, just wanted to give you one more example that shows that the blue line may be better than the red line using the routing principles recommended by Ms. Prech. Ms. Prech testified in her pre-filed testimony that has been submitted into this record that in routing a transmission line, there are what she refers to as constraints and what she refers to as opportunities. Constraints are those things that will impede the transmission line, and you want to stay away from those constraints as much as possible. Opportunities are those things that attempt to incorporate are things that are good for the transmission line, and you attempt to incorporate those as much as possible. That makes perfect sense, right? So one of the constraints identified by Ms. Prech in her testimony in this case are center pivot irrigation locations. To the extent possible, you want the transmission route to stay away from those locations. If you take a look at Mr. Owens' exhibit PCO-3, you can see that Grain Belt's red line impacts 5 center point irrigation locations on the Boyd's properties, where the Boyd blue line route impacts no center pivot irrigation locations. Mr. Boyd pointed this out in his public comments that are in the record. The evidence already provided to you in this record shows that the Boyd Alternative 2 route is reasonable and, like the commission has done in other citing cases, deserves a second look. However, because of the statutory time deadline in this case, the commission would need to consider the route across the properties owned by Boyd in a second hearing, which is provided for in the settlement agreement before you. Approving the settlement would allow the bulk of this case to move forward and decided by the commission. The commission certainly can go forward to approve the Buckland line route and the Meade Dodge City line route as part of this case, and then under its authority to place conditions in its order in this case. And it's my understanding that there will already be a number of conditions in this order. The commission can approve the settlement that has been submitted by the parties in this case and go forward and approve that application that's been made. By agreeing to the settlement, you will basically allow for all of the information that is necessary to make a decision on where the route of the transmission line should be across the Boyd's property. The public who will ultimately benefit from the sacrifices being made by the Boyds owe that to this family who have owned this farm since 1884. If it was your family farm, you would expect that the commission would take the additional time and effort, and only after receiving all the information available so they can make sure that they get their decision right to then make their decision. The Boyd interveners would request that the settlement agreement filed by Grain Belt and the Boyd interveners and not opposed by staff be approved by the commission. I'd be happy to answer any questions that you might have regarding the settlement. Also, Mr. Boyd is present today, and he would also be happy to answer any questions the commission has. Thank you.
All right, thank you. For NG, Mr. Jim Zakura.
Good morning, Commissioners. We have a limited participation in this case, I think. As you can see, we're not offering a witness. But in my opening statement, I did want to relate to the Commission the areas of inquiry that we'll be dealing with in our presentation. The first is from the application, and it is footnote number 3 in the application. And it says, the Meade line and the Buckland line have been sited and designed to be in proximity to renewable energy projects under development that have applied to the queue, and both transmission lines will be open to interconnection requests at those points. We're interested that that will be a fair and even process, that those parties who wish to participate in Grain Belt can do so on a non-discriminatory basis. And I do want to say to the Commission, we are supportive of the Grain Belt line at NG. We would like to see it be in successful operation. I think the principles that have guided the Commission since 2011, if you can believe it, are still in effect. That is, the Grain Belt line does create an additional market outlet for Kansas wind energy. And that remained, in 2011, when that was stated, it was important. In 2024, it's yet more important because we have about 9,000 megawatts of wind in Kansas. And from time to time, that gets shut in because of congestion. While supporting the commission's position as to the appropriateness and the public interest of grain belt, we also fully support the commission's conditions that have been placed on the certificate. The conditions basically were down to two areas. Number one, that you don't start a project like this unless you have the money to finish it. And number two is that there needs to be those people who have looked at this project, that being resource developers, who have engaged and will contract to be attached to the system. And I think the parties dealt with that second issue in the conditions that are before the commission today. As far as the disputed issues, we have just a few. The first one is on the list of disputed issues, it's number 6. And the statement is Grain Belt Express has agreed to continue to engage with ENGIE, including coordinate on the location of existing infrastructure and on safe installation during the construction period. We intend to inquire on just what that means, that general statement, in this case. The second areas, and this is where it kind of throws us for the loop. Number 8 has numbered paragraphs under it of the disputed issues. And we are looking at essentially those parts of the of number 8, number 4, first of all, which is Grain Belt Express will file the Southwest Power Pool's feasibility study, planning study, and design study when
Can I
they're
have you
available.
slow down just a touch?
Yes.
Go ahead.
I was trying to lead the commission through the difficulty I had. Number 8 has numbered parts under it of the disputed list. And the first one that we have an interest in would be item 4, which is the Southwest Power Pool study. We're unclear on that. As I've researched this, there have been Southwest Power Pool studies on this that date back to 2016. So we need, I think, in the record some further definition of that. Then the additional ones that we have to do with the interconnection and the master plan. Okay, we want to know more detail about the master plan to the extent that the company can provide it, and that would include where the lines will be located, how much volume for each line is predicted. And most importantly, we would like, if possible, from the company to give us some indication of when they believe there will be an in-service date of the Grain Belt project. The final thing, and I spoke with the company, we're going to have a dispute on this for sure, and that is what, if any, is there an interrelationship between the commission certificate in this case and the national interest electric transmission corridors? We just wanted to explore that a bit. The company does not agree that's appropriate in this case, and we'll present that for the commission then to make a decision. Thank you very much.
All right, thank you. Mr. Calcara for Sunflower.
Good morning. May it please the commission. Sunflower Electric Power Corporation is a generation and transmission electric utility operating in the state of Kansas on a nonprofit cooperative basis, with its principal place of business located in Hays, Kansas. Sunflower is a coalition of 6 Kansas consumer-owned cooperatives and 1 corporation wholly owned by one of the 6 Kansas consumer-owned cooperatives, which I'll otherwise refer to as the Sunflower's members. Sunflower owns transmission lines of various voltage levels in the general area traversed by the AC collector lines. In addition, Sunflower's members own distribution facilities that connect to those same Sunflower transmission lines. Those member distribution facilities serve Kansas retail ratepayers in western Kansas. The reliability of the electric grid can have economic impacts on the Kansas retail ratepayers. The less reliable an electric facility, the greater the negative impact to the customers it serves. The Commission must take into consideration in this docket the benefit to both consumers in Kansas and consumers outside the state and economic development benefits in Kansas. In addition, to determine the necessity for the proposed electric transmission line, the Commission historically has applied standards similar to those applied in a Certificate of Convenience and Necessity proceeding. As in certificate proceedings, the Commission term necessity does not require a finding of absolute need, but rather a finding of public need without which the public is inconvenienced to the point of being handicapped. The Commission also considers the economic impact on Kansas, including construction jobs, taxes, and landowner payments for easements. The purpose of Sunflower's participation in this proceeding is to address the economic impact on Kansas. More specifically, Kansas ratepayers that are member owners of Sunflower's member owner distribution cooperatives. As outlined in direct testimony filed in this proceeding, Sunflower is concerned about reliability impacts of the AC collector lines on the grid that could cause negative economic impact to Kansas retail ratepayers. The transient impact of adding large AC collector lines to the larger direct current line is still unknown. Each AC collector line will carry a large amount of power, and any interruption that occurs may result in a transient event, in other words, flicker, voltage dips, etc., which will be experienced by customers in and around Dodge City. If the transient impact is significant, in addition to residential load impact, the result may be that a number of large industrial loads experience an interruption in electric service. Interruptions in service have real negative economic impacts on large industrial customers. In addition, the transmission system around Dodge City is considered a weak system with little inertia to help mitigate large flickers. As is described in more detail in Dr. Al Tamimi's direct testimony, a large power drop on the AC collector lines in a weak grid area like Dodge City has the potential to create negative impact on the electric loads in the area. Finally, the AC collector lines will parallel one of Sunflower's transmission lines, and the potential for mutual impedance exists. Greenbelt refers to docket number 11-GBEE-624-COC in its application and testimony in this proceeding. In that docket, the Commission approved Greenbelt's original certificate as a transmission-only public utility in Kansas to construct, own, operate, and maintain an overhead, high-voltage, direct current transmission line and associated facilities, including collector lines. The Commission conditioned that approval with the restriction, an agreement from Greenbelt, that the cost of the project and any AC collector system owned by Greenbelt would not be recovered through the SPP cost allocation process or from Kansas ratepayers, other than de minimis costs ancillary to any needed interconnection to the SPP. Today, the reliability impact of the AC collector lines is simply unknown. Greenbelt concurs that the studies necessary to examine the reliability impact have not been completed. Given its size and complexity, the Greenbelt project has taken a significant amount of time to develop, and it seems likely that it will take a significant amount of additional time before the AC collector lines are operational and all parties can truly understand the reliability impacts in real time. That said, the Commission must make a decision today in this proceeding on Greenbelt's pending application. To ensure that Greenbelt's existing agreement from docket number 11-GBEE-624-COC is continually and consistently enforced, and that Kansas retail ratepayers do not bear the cost of Greenbelt's AC collector lines, Sunflower respectfully asks the Commission to condition any approval in this docket on Greenbelt reimbursing Sunflower for its reasonable costs of studies regarding the reliability impact of the AC collector lines, as well as Greenbelt paying for mitigative actions identified by Sunflower's studies. Thank you.
Thank you, Mr. Calcara. Finally, Ms. Mazantine, KCC staff.
Yes, good morning, Commission. As you are aware, the Commission first approved Greenbelt's application to become a public utility and build this project partially in Kansas back in 2011. And it did that because the Commission found benefits associated with the project. Benefits such as moving congested, low-cost wind from western Kansas to states further east, without burdening Kansas customers with the associated costs, and improving the transmission system in Kansas from a technical and reliability perspective, while also aiding in the development of Kansas wind resources. In developing Kansas wind resources was found to be vital to promote economic growth in the state. So turning to the instant application, per KSA 66-10178, the Commission decides the necessity and reasonableness of the location of the proposed route of the AC collector lines. KSA 66-10180 requires the Commission to consider the benefit to both consumers in Kansas and consumers outside the state, and the economic development benefits in Kansas when determining the necessity and reasonableness of the location of the lines. This same law allows for the Commission to condition a public utilities permit as the Commission deems just and reasonable, and as may best protect the rights of all interested parties. As of Friday, the Commission has been asked to approve a settlement agreement between Grainbelt and the Boyd interveners. Staff's written testimony supports Grainbelt's originally proposed route, but contemplates that the Boyd alternative has merit, such that staff could support that route as well, subject to further analysis and the relevant notice periods. Therefore, staff is unopposed to the proposed settlement agreement, because that agreement would allow for the further analysis and relevant notice period. Staff witness Paul Owings is here and at the appropriate time will be made available to answer questions regarding both the originally proposed route and the Boyd alternative. Thank you.
Thank you, Ms. Mazantine. All right, we have concluded opening statements. We've been going less than an hour, so I think we will continue for a bit longer. We're going to move to examination of witnesses, and we will begin with Grainbelt's witnesses. Mr. Schulte, would you like to call your first witness, or Ms. Kallenbach?
Thank you. Good morning. Grainbelt Express calls Kevin Chandler to the stand, please. Chair French, if I may, we had one correction that we noticed when Mr. Zakora was going through the list of disputed issues. Is it possible to take time to make that correction just on the record?
Are you going to do it through examination of the witness, or is this something you wish to just correct
If I could just
administratively?
correct it, it was not sponsored by Mr. Chandler, if it's possible just to correct it.
Okay, let's go ahead.
Thank you. I'm referring to the filed joint list of disputed and resolved issues that was filed on Monday, August 19th. On page 4, paragraph 8, subparagraph 1, there is the word with appearing in that sentence that was an inadvertent error, and that with should be stricken. It does not change the meaning. It's simply, we just like to correct it so it's
Okay.
more clear.
I'm
Thank you.
assuming there is no objection from the other joint parties to that filing. It does look like a typo to me.
Yes, sir. It is a typo.
All right, we will make that correction then. With that, before you begin your examination with Mr. Chandler, why don't we go ahead and swear in the witness?
So would you raise your right hand? Do you solemnly swear or affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth?
All right, go ahead.
Thank you. Good morning, Mr. Chandler. Would you please state your name for the record?
Kevin Chandler.
And by whom are you employed and what is your title?
I am employed by Director of Development, Director of Transition Development. Director.
Is your microphone on? Press the gray button. There you go.
There we go. That sounds better. Yes, Director of Transmission Development.
Thank you. And are you the same Kevin Chandler whose direct testimony, rebuttal testimony, testimony in response to public comments, and rebuttal testimony to staff's response to public comments and accompanying exhibits have been entered into the record in this proceeding?
Yes, I am.
Do you have any additions or corrections to make to your testimony at this time?
I do not.
If I asked you the same questions again today, would your answers remain the same?
Yes.
Thank you. I have no questions and will tender the witness for cross.
All right, thank you. First on my list is the Boyds, but I understand the parties have waived cross-examination as a result of their settlement. So I will move to NG. Do you have any questions for this witness?
Yes, please.
Mr. Chandler, good morning.
Good morning, sir.
I'm Jim Zakora, representing the NG companies. Okay. First of all, can we deal a little bit with structure? I believe I'm correct, but I think you indicated that you're employed by Evidentiary.
Yes,
And who is the owner of Grainbelt Express currently?
it is currently Invenergy
Okay. And,
or Invenergy Renewable, Invenergy, yes.
okay. And in your position with Invenergy, you have responsibility for Grainbelt as expressed in your testimony. Would that be correct?
Yes, I am a member of the Grain Belt Express transmission development team.
Okay. Let me first congratulate you on your work. We think it's a needed project. And my first question is, what do you expect the in-service commercial date to be for Grainbelt?
We anticipate beginning construction as soon as 2025 with anticipated in-service of 2029.
Okay. And can you be, sir, any more definite when you say in 25 and in service in 29? Can you break that down by calendar quarter, for instance?
I would anticipate later in 2025. And I can't give a quarter in 2029 myself.
Okay. And sir, when you were speaking of the commencing construction in the in-service date, would that, sir, be the phase one of the Grainbelt project?
That is correct. Thank you for clarifying.
And could you, sir, describe what phase one of the Grainbelt project is?
I believe phase one is defined as the portion of the Kansas HVDC facilities designed to convert the AC to DC for phase one. And then it would be the 2,500 megawatt capacity line that runs to the Missouri converter station, inclusive of the Missouri Tiger connector, which is the delivery transmission line into MISO and AECI.
And I believe you said that the delivery is 2,500 megawatts. What do you anticipate the capacity of the AC collector system to be?
So I should clarify that within that 2,500 megawatts, approximately 1,500 megawatts will be delivered into MISO and approximately 1,000 into AECI.
Thank you, sir.
Yep, sorry.
And my question is, to make those 1,500 and 1,000 megawatt deliveries, how much capacity of renewable energy must be interconnected in the AC collector system?
The interconnection capacity will be determined in large part based on the interconnection studies that are ongoing. I believe Mr. Rodriguez from the interconnection team would be a better place to give you a definitive answer to that.
Let's turn, if we could, sir, to footnote 3 of the application that I indicated to the commission in my opening statement.
Do you have a page number?
It is page 1.
I need a copy, I'm sorry.
Council, may I proceed? Okay, thank you. I would please, sir, direct your attention to footnote 3. Do you have that before you, sir?
I do.
And I would like to read this, if I could, to the record. The Meade line and the Buckland line have been sited and designed to be in proximity to renewable energy projects under development, and then I'm putting in one, that have applied to the queue, and I'm putting in 2. Both transmission lines will be open to interconnection requests at those points. And these are my questions, sir, about that particular footnote. Has Grainbelt or Invenergy appointed a group to receive applications for placement into the queue?
Could you I don't think I understand the question.
Okay, let me rephrase it, please. Is Energy receiving these applications, or has Energy appointed a third party to receive applications for placement in the queue?
Is energy receiving, sorry,
Perhaps I should save that for Mr. Rodriguez. Is that a better? Let me rephrase it again. Okay. How many applications has Invenergy received to interconnect at this AC collector system?
I believe we have noted in our, in the testimony that we've received 14 applications.
Okay. And of those 14 applications, has Invenergy finalized and executed any agreements with any of those parties?
No, I believe, as Mr. Rodriguez will be able to better detail, we are currently undertaking a cluster study process to analyze all of the projects that have submitted applications into the queue.
Would you be able to provide for the record, sir, the total amount of capacity of those, I think you said 14 applications in the queue?
Yes, I believe those have been submitted in the testimony in response to a data request.
And do you recall the volume of that, sir?
Yeah, I believe that response was provided as a confidential response to KCC 3.
And what was the volume for the record, sir?
Yeah, excuse me, Chair French. That response to KCC 3 is confidential. If we could either defer questions on confidential information to a later point, or a different process, as you would prefer.
Yeah, we'll defer it. Did the witness indicate that is already attached to confidential testimony?
It is not attached to testimony. It was a response to a DR that was deemed confidential.
Okay. Yeah, we will go ahead and refer that to any, a confidential setting if that's needed. Although I might need more information on the relevance to this proceeding before we go toward a confidential setting.
Do you want me to address that now, or would you prefer I?
Why don't we move on with public questions, and then if we have a need for a confidential setting to address confidential information, we can talk about the relevance at that time.
Okay. May I ask one further question? Is there anyone in the room who has not executed a non-disclosure agreement? Oh, I'm sorry, I forgot. We're on the internet.
We are on
right?
YouTube.
You would think I would know better. Thank you, Brian. I'll proceed. Okay. Let me go back a moment. Do I understand from your prior testimony that at this time, to your knowledge, there are no executed interconnection agreements for the AC collector system?
Correct.
I think I have just one more question about that. Would you be able to say how many different companies have applied for interconnection? Is it, of those 14, is it all the same company? Are there 2 or 3? Are there 10?
Again, this was provided in response to confidential response to KCC 3. And so I think it would be part of any confidential discussion later.
Okay. Let me turn to the stipulation, if I could. And some of these questions I think will probably be for you and some will be for your colleague, Mr. Rodriguez. But at this time, sir, would it be your intention to file additional requests for additional AC collector systems? Or do you believe the pending AC collector systems will garner sufficient volume that an additional master plan will not be needed?
So in this application, we differentiate between the AC collector system and the AC collector lines. So this filing addresses 2 AC collector lines within the AC collector system. We do foresee the potential for additional filing of AC collector lines that would be preceded by an AC collector system master plan.
If that is the case, sir, would it be your estimate at this point in time that you will be coming back to the commission with an AC master plan?
Yes.
Let me, sir, direct your attention to number 6 of the conditions. It's the joint list of disputed issues.
I think I need a copy here.
Mr. Chairman, can we approach the witness and provide a copy?
Thank you.
Counsel, may I proceed? I would please direct your attention to number 6 of the joint list of disputed and resolved issues, which is dated August 19, 2024, and filed at the commission. Do you have that before you, sir?
I believe so.
And I'm particularly going to ask you about the last sentence. Grainbelt Express has agreed to continue to engage with NG, including coordinate on the location of existing infrastructure and on safe installation during the construction period. Could you expand and expound on that as to what that sentence means to you?
So I take this to mean as coordination with NG on the location and construction plans for the AC collector lines relative to, I think in this case, the Iron Star Wind Project is the operating project with existing facilities in the area. So we would coordinate with the company. We post approval of the lines. Our intention is to survey the parcels impacted by the AC collector lines to determine appropriate parcel boundaries, as well as to coordinate, as well as to assess the existing above and below ground infrastructure on those properties. And then it is our standard practice to coordinate with the owners and operators of existing utility infrastructure on those properties. So this would be part of that process and coordinating with NG.
Sir, would that be limited only to the process that's already developed, the Iron Star? Or would that also include the 3 other projects of NG that are in development in the area?
It would be our intention to coordinate with NG on the existing Iron Star project as well as future projects that are in planning and reasonably likely to occur.
Thank you. Let me ask you a question if I could in this regard. Is there a requirement that a resource developer use the AC collector system? May instead a developer build its own line over to the switch yard?
It is my understanding that a developer would have the option to either interconnect via the AC collector system or develop their own transmission line to interconnect at the AC switchyard adjacent to the Ford County HVDC converter station.
Thank you, sir. Would it also be your opinion that a party other than Greenbelt could build its own switch station or substation and interconnect at that point with Greenbelt?
Could you explain what you mean by that point?
The point of interconnection with the main transmission line, the HD line.
So are you suggesting an additional switchyard adjacent to the planned Ford County switchyard, or?
It could be there, or it could be a place that's agreeable between Greenbelt and the developer.
I'm sorry, could you rephrase the question one more time?
Certainly.
Sorry.
I think in your prior question, as I understood your answer, you indicated that a resource developer could build its own line over to the switchyard that would be owned by Greenbelt. And my question, the second question was, could the developer also own its own switchyard and still be interconnected?
While not an interconnection expert, I believe yes, if that is the choice, if it is the choice of the other party that feels they would need that infrastructure and is prepared to take on the cost, I think the answer would be yes.
Let me ask this question, and it may be better reserved for Mr. Rodriguez. Do you have knowledge about the SPP study, or would that be more appropriately directed to Mr. Rodriguez?
That would be more appropriately directed to Mr. Rodriguez.
Thank you. I have nothing further.
All right, thank you. Does Sunflower have any questions of this witness? Go ahead, Mr. Calcara.
I think I can manage this all from up here, but give me just a second. Good morning, Mr. Chandler.
Good morning.
My name is Taylor Calcara. I'm a counsel for Sunflower Electric Power Corporation. I don't think we've met before, so.
No, pleasure.
Good to meet you too. Just have a few questions I'd like to ask you with respect to your testimony. Do you have your testimony with you?
I do.
Okay, I'd like to start with your direct testimony that you filed on May 31st, 2024. And I'd point you to page 12 of that testimony. You can let me know when you're there.
I am there.
Okay, I'm looking at lines 4 and 5 and lines 14 and 15. And you state that Grainbelt will not be seeking recovery of any capital costs from Kansas ratepayers. And then again, that energy customers in Kansas will not bear capital costs associated with the AC collector system. Could you please explain what all is included in capital costs of the AC collector system?
I take that to mean the costs associated directly with the development and construction of the AC collector system.
Could you clarify what costs would be directly associated with the construction and operation?
Yeah, I think, most specifically the direct cost of the transmission lines, structures, conductors, as well as the soft costs associated with bringing that about.
So if the AC collector system caused a reliability impact on, say, the SPP system, and maybe more specifically, transmission facilities owned by Sunflower, would the cost of any equipment installed on the SPP system be a capital cost of the AC collector system?
I am not an expert in the SPP process, but my assumption is I'm not sure.
Outside of the SPP system,
Yeah.
would you consider that to be a capital cost of the AC collector system?
I'm sorry, could you rephrase the question again?
Sure. I think what you're trying to describe as capital costs are just the direct costs of the steel for your physical line. Would that be fair?
I would not say it's only the direct costs of the steel.
Okay, let me rephrase the question. If the AC collector system caused a reliability impact to Sunflower's system and Sunflower had to install equipment on its own system, would the cost of that equipment be a capital cost of the AC collector system?
Again, not being an expert, I cannot say definitively, but I do not think so.
So if there is a mitigative solution to the reliability impact that's caused by the AC collector system, it's possible that Sunflower could have to pay the cost of that mitigative solution?
I think this question may better be asked of Mr. Rodriguez.
Okay, what's your testimony?
Yep. It's my understanding that there's that any costs associated with mitigation for reliability issues would be addressed within existing SPP processes through existing working groups. And I do not believe those are capital costs as defined in this application.
Well, regardless of the way that SPP defines them, how are you defining them in your testimony when you refer to capital costs?
So again, the capital costs are associated with the development and construction costs associated with the AC collector lines, the development and construction, and there could be some ongoing operational costs associated with the operation of the AC collector lines. All of these costs will be collected from parties that are interconnecting into the AC collector system. So the generation projects that are participating in Grainbelt.
So if equipment is installed on Sunflower's transmission system to mitigate an issue caused by the AC collector system. Your position is those are not capital costs as referenced in your testimony.
I do not believe those are capital costs as defined here.
So then Sunflower and its customers would bear the cost of that equipment.
That gets into interconnection studies and procedures of which I am not an expert.
Again, outside of any interconnection process through SPP, according to your testimony, Sunflower would pay for those costs because they're not capital costs.
I would assume, I do not know, they're not defined, they're not capital costs as defined here. How those are paid for is not something I can speak to.
But the commitment from Grainbelt in your testimony would be that Grainbelt is not committing to pay for those costs.
Yeah, I need to object to that. I think that misstates the witness's testimony.
Well, I'm trying to figure out what his testimony actually is.
Mr. Kilcara, can I ask you, this is a little unorthodox, but I just want to ask you a clarifying question. When you are talking about mitigating investments that Sunflower might have to make, you are not referring to investments that are the result of the interconnection process at SPP. You are referring to investments that Sunflower chooses to make on its own accord, correct?
Well, I'm just trying to figure out, the commitment from Grainbelt is that it will not be seeking recovery of any capital costs. I'm trying to understand that definition to understand the extent of that commitment.
Yeah, I'm just trying to delineate which capital costs you're talking about. Are you talking about capital costs identified, investments identified by the SPP interconnection process? Or are you talking about investments identified internally at Sunflower?
Either or.
Okay.
I can move on. I think I'm good. This may make more sense as I move on to my next line of questioning. Would that be okay?
That's fine.
Mr. Chandler, I'd like to point you to the application for a moment. The application references docket number 11-GBEE-624-COC, which is where Grainbelt sought and received commission approval for a certificate of convenience and necessity to transact business as a transmission-only public utility in Kansas, to construct, own, operate, and maintain an overhead multi-terminal plus or minus 600 kV high voltage direct current transmission line and associated facilities. I know I just gave you a mouthful there. Would you accept that subject to check of the record in that docket?
Yes, subject to check.
Okay. Were you involved in that docket?
No.
Okay, the application references the order approving stipulation and agreement in that docket, which was filed on December 7th, 2011. Your testimony also references that order on page 15. Chair French, I'd like to ask some questions with respect to that order. I'm wondering if for clarity of the record, it may make sense for me to move for that to be admitted as, or for the commission to take administrative notice of that order.
If it's a previous commission order, we will take notice of it freely.
Okay, thank you. Council, I'm going to ask some questions. Do you want a copy of this? Do. I've got one for the witness too. Would it be all right if I approach? I do have, Chair French, an extra copy if you'd like one.
If it's an extra floating around, I'll take it. Okay, fantastic.
I believe I've tabbed the page that I'd like to ask you some questions about, but for clarity of the record and counsel, I'm in the actual stipulation and agreement that was attached as an exhibit. I'd like to focus in on, it would be paragraph 4, C as in cat. I'm just going to go through that quickly. It's not very long, but what it states is that is the intent of the signatories that the cost of the project and any AC collector system owned by Cleanline will not be recovered through the SPP cost allocation process or from Kansas ratepayers. As such, the signatories recommend that the Commission's order condition the granting of the certificate upon Cleanline's representation that there will be no project or AC collector system cost allocation to SPP or recovery of project or AC collector system costs from Kansas ratepayers other than de minimis costs ancillary to any needed interconnection to SPP. Are you with me? Do you see where that's stated?
I do.
Could you tell me, Mr. Chandler, does the language that I just read you, well, let me, before I get to that, would you accept for the record that this was approved by the commission in that docket, subject to check?
Yes.
With respect to the language that I just read you in the restriction on cost recovery from grain belt, do you see any reference to capital costs in that language?
I do not see a direct reference to capital costs.
Why in your testimony did you limit the restriction on cost recovery to only capital costs?
I think if you look on page 4, where it states that there will be no project or AC collector system cost allocation to SPP or recovery of project or AC collector system costs. Sorry. There will be no project or AC collector system cost allocation to SPP or recovery of project or AC collector system costs from Kansas ratepayers other than de minimis cost ancillary to any needed interconnection to SPP. So believe the reference to capital cost was intended to make reference to costs other than de minimis cost ancillary to any needed interconnection to SPP. And as stated previously, this is not my area of expertise, so any follow-up question here I think would probably be better answered by Mr. Rodriguez, although I'm happy to try to answer any questions.
What are you relying on to conclude that de minimis costs ancillary to any needed interconnection to SPP swallows the cost that I've been referencing?
Again, I would probably refer that question to Mr. Rodriguez.
So you're unsure why you limited your testimony to a restriction on capital costs in light of this restriction in a previous order?
No, as stated, the capital cost definition or the capital cost inclusion in the application was intended to encompass costs other than the de minimis costs referenced here. But again, I would refer to Mr. Rodriguez for more detailed discussion of the SPP process.
So I think what I hear you saying is you believe that the restriction in this order is consistent with your testimony that Kansas retail ratepayers will not bear the costs of only capital costs of the AC collector system.
I believe that my testimony is consistent with the order.
Does the language in the order that we've been addressing have any reference to Grainbelt only paying for costs of the project that are identified through an SPP process?
Mr. Chair, I'm going to object to this. I think the witness has answered this question repeatedly. I don't see that we need to pursue this any further.
I've just asked for the first time about the SPP process. I'll move on after this question.
I will let the witness answer. We're getting very close to asked and answered.
Having not read this entire order in some time, I cannot state what else may be in here.
Understood. I'll move on. I'd like to point you to page 13 now of your testimony. I'm still on the direct. I'm clear down in line 24 that actually wraps over to page 14 down to line 3, where you state that the bidirectional capabilities must be certified or otherwise allowed by RTOs. Has SPP certified or otherwise allowed bidirectional flow on the Grainbelt project?
To my knowledge, SPP has not yet certified the bidirectional flow.
Has MISO certified or otherwise allowed bidirectional flow on the Grainbelt project?
To my knowledge, they have not. And again, I will also state that I think Mr. Rodriguez will be able to provide more detail about what that entails.
Okay, that's fair. And just for clarity, PJM hasn't certified or otherwise allowed either, to your knowledge? And I'll ask these questions to Mr. Rodriguez too.
I am less certain of the PJM.
Okay. I'd also just like to ask you a question. You reference, I'm on page 14, line 2 to 3, that this line serves as a zero marginal cost benefit to the states. Could you just explain to me what you mean by that statement? What is a zero marginal cost benefit?
So the full sentence says, therefore, this line serves as a zero marginal cost benefit to the states along the line because the line provides an option for emergency imports of energy and black start capabilities without dependency on local generation or on-site fuel. So by Grainbelt existing as by Grainbelt having the capabilities to provide those services external to existing resources within the system, we are providing that benefit at no additional cost to the states.
Okay, I think I want to jump now to your rebuttal testimony that you filed on August 14th, 2024. I'll give you a second to get to that.
Yep.
Just, I'm down in line 16 and 17, where you reference that if the SPP studies are evaluated by SPP and determined to be.
Sorry, what page are you on?
Oh, I'm sorry. I apologize. Page 9. That would probably be helpful, wouldn't it? Page 9, lines 16 and 17.
Sorry. My page 9 of that does not look like it matches up with what you were just reading.
Let me make sure I'm looking at the right, your rebuttal testimony of Kevin Chandler to staff response to public comment filed August 14th, 2024. Page 9.
Yeah, sorry, I was in the initial rebuttal testimony.
Oh, I'm sorry.
Okay, there we go.
Okay, line 16 and 17, where it says if SPP studies are evaluated by the SPP determined to be inadequate. Apologies. If the SPP studies are evaluated by SPP and determined to be inadequate, there are procedures in place at SPP to address any concerns. Has SPP completed the studies you're referencing?
I would refer to Mr. Rodriguez, who has more detailed knowledge of the current status of those studies.
Okay, that's fair. You do say, though, that if they are determined to be inadequate, there are procedures in place at SPP. What are those procedures?
I would again refer to Mr. Rodriguez to provide a substantive answer to that question.
Well, again, this is your testimony, Mr. Chandler.
Yep. I have been advised by Mr. Rodriguez and others on our interconnection team that there are procedures in place, and Mr. Rodriguez is available for testimony on those issues.
Okay, thank you, Mr. Chandler. No more questions.
Thank you. We have a few more parties to ask questions of Mr. Chandler, but we've been going for an hour and 45 minutes. I hate to do this in the middle of a witness, but I think I am going to give everybody a short break. So we're on pause, Mr. Chandler. You're not stepping down quite yet, but we are now off the record. We will return in 10 minutes. You can. You may physically step down. Don't leave the building.
I apologize. Keep going. I'll try to be slow.
This is all new to me. I've never done any of that. I didn't know your way. No, I didn't. Very drastic. More than I want to admit to.
Y'all have to.
Yep.
All right, it looks like we have critical mass. Before we go back on the record, just a request that everyone make sure your cell phones are on mute. So we are recording, it's going out over the internet, so we want to have it nice and quiet and here for the mics to pick up. Are we ready to go? All right, we are back on the record in the hearing for this proceeding. Mr. Chandler is on the stand and we are ready for any questions from staff.
No questions from staff.
Okay. And then we will move to commissioner questions. Commissioner Keene, do you have questions of this witness?
Yes, thank you. Good morning, Mr. Chandler.
Morning, sir.
In transmission line siting dockets such as this one, a major concern that I have has to do with the compatibility of the lines proposed to be sited with other uses of the land. Of course, we are preeminently concerned about the impact on residences and rural structures and buildings. I guess that's correct, is it not?
Yes, those are two of the primary concerns.
Okay. Beyond that, however, there are at least two prominent and I think relevant commercial land uses that must be considered, namely agriculture and in Kansas, especially southwest Kansas, oil and gas production facilities. Is that fair to say?
Yes, sir.
My first two questions pertain to these uses, and I'm most interested in preserving for the record and having the company on the record with respect to your take on compatibility. So let's first take up the agricultural uses. In the opening statement, Mr. Schulte detailed, I think rather extensively, a lot of the communication processes that took place with respect to the interplay between landowners and the company and providing at least a conduit for communication. Is that a fair statement?
Yes, sir.
And then we had, following that, we of course had Mr. Flaherty's explanation of the position the Boyds are taking, which I thought was also quite detailed. So my first question is with respect to agricultural uses, and I'm talking about not just the Boyds part, but the entirety of both of these lines, the 46 miles encompassed by the Meade to Dodge City line and the 16 miles encompassed by the Buckland to Dodge line. The question is this: in connection with the construction, operation, and maintenance of these two lines, if you could tell us with respect to the entirety of the lines, not just the portion that the Boyds have here, what accommodations have you made or are you making? And prospectively, could you at least summarize accommodations you are making to ensure compatibility between the lines and agricultural uses? And I would appreciate too, if you would, with some particularity, discuss that interplay, given the the high extent, I think, of irrigated center pivots and irrigated lands in southwest Kansas and the counties covered by these lines.
Yes, sir. So appreciate the question and would agree that it is also Grainbelt Express's intent to minimize interference with agricultural operations as well. In the routing and siting process associated with these lines, we have sought to minimize impacts to center pivot irrigation, and to the extent that lines are crossing areas that are irrigated, we are, I believe for the entirety of both routes, we are generally following existing infrastructure, whether it's county roads or parcel lines or to some extent existing transmission lines. We believe, based on our analysis, that any center pivot systems are spannable at this point. And what we mean by that is just we don't believe that we would need to place structures within the path of existing pivot systems. So it is our intent to avoid interference with existing irrigation to the greatest extent possible. We have also agreed to contact landowners regarding the height of their equipment. We are aware that this part of Kansas has a lot of large equipment associated with harvesting, and it is our intent to coordinate with landowners regarding line height to preserve as much access for those vehicles as possible. And then the last thing, I was flipping through trying to find it, but I would just would highlight the agricultural impact mitigation protocol and landowner protocols that we filed as part of this docket and as part of Mr. Fine's testimony. And those represent a series of commitments regarding how we will coordinate with landowners regarding agricultural uses on property, as well as mitigation and restoration during construction and during the operations period. And it is our understanding that those commitments are more robust than what is typically seen by other utilities. And we hope that it reflects our desire to work with landowners. We recognize that the transmission lines will be in the area for quite some time when built, and we want to maintain a good relationship and ensure that landowners are still able to maintain agricultural practices on their land.
Okay, I've noted those protocols, and I think in terms of specificity and detail, it helps to have that set out and have that laid out. Did you have, with respect again to ag uses, did you have any circumstances throughout the entirety of the routes of both of these lines? Do you have any circumstances that were somewhat analogous to the concerns the Boyds had about the potential interference with either the irrigation equipment or other issues that were somewhat analogous to theirs?
I think based on our experience during the open houses and in receiving feedback from landowners, initially, if you looked at the potential route network for the Meade line in particular, there was a pretty significant extent that paralleled an existing transmission line. And initially, a lot of feedback that we get on routing is people often want us to follow that existing infrastructure, and paralleling existing transmission lines can be a good routing opportunity. But we heard quite a bit of feedback from landowners in the study area about the challenges that in particular would present to pivot systems and just general maneuverability, which I think helped lead to the choice of the proposed route that parallels Highway 23 and other county roads for a much greater extent, and we believe should allow for more unimpeded agricultural practices on those properties.
Okay. Let's turn to the second major commercial use that I noted at the outset. So my question to you is this: in citing construction and the anticipated maintenance of these lines, what accommodations are you making and will you make in recognition of oil and gas leases, oil and gas production facilities, and storage facilities?
So as noted in the response to one of the earlier questions, it is our practice when commencing development of a transmission line to utilize a third-party surveying contractor to perform boundary surveys as well as analysis of existing above and below ground infrastructure on properties. And that helps us to capture the precise precise boundaries, which is not always as straightforward as you might think, as well as that location of the existing infrastructure gives us a better understanding of to what degree the transmission lines may or may not interact with that existing infrastructure. And then once we have that, we begin consultation with the owners and operators of that. So, for example, a pipeline, we will begin dialogue with the pipeline company better to understand what is there. And then as needed, we perform interference studies to understand what kinds of mitigation may be needed. So that can involve changing the alignment of the transmission line to avoid impacting that infrastructure. It could also involve other engineering decisions, of which I'm not an expert, but ultimately any mitigation or alignment shifts are typically captured in a third party. We call them a crossing agreement, which is an agreement that we will formally execute with the owners of that infrastructure. So that is a pretty lengthy and involved process, as you can imagine, for long lines. There are quite a number of these, but we take that process very seriously, and it's our intent to perform that level of analysis for these AC collector lines.
Well, aside from pipelines, which there are extensive pipelines in place, certainly within Southwest Kansas, through over major parts of the state for that matter, I'd like to have you just hone in a little more specifically on accommodations you make with respect to oil and gas production facilities and storage facilities.
Yeah. So
let me tell you why I have that concern.
Sure.
These oil and gas leases, many of them out in western Kansas, may be quite old. Once those leases are propelled into the secondary term, they remain in effect for as long as there's production in paying quantities. That can be for a very long time. And there are, within the confines of that relationship between the operator that has that lease and the landowner, there are contractual relationships that are identified, express conditions within the confines of the lease. There are implied conditions in the law, implied requirements that require, among other things, their covenants to develop, requirements to develop. It's conceivable that that could come in conflict with these kinds of lines. So, that is far beyond even the mere day-to-day operations of trying to produce oil and or gas, store it, process it, sell it, and try to produce that in paying quantity so that the lease may remain alive. So with that rather verbose interruption there, I'm interested in how it is that the company plans to accommodate oil and gas production facilities, including storage facilities.
Yeah. So it is our general intent not to, general intent to avoid impacts to existing production facilities. If there were any scenarios where those impacts were unavoidable, we would seek to provide accommodation to the landowner and the owners of that infrastructure, but we will always seek to avoid those impacts. And regarding to your question about potential future development, that is part of the conversation we have with landowners to understand what other land uses are on their property, and we will seek to accommodate those additional land uses to the extent that is feasible.
Well, I'm concerned about the welfare of the landowners.
Yes.
In the case of an oil and gas lease, they're the lessor, but I'm concerned about the welfare of the lessee, which is the other side of that contractual relationship. Those are the operators. I'm wondering if this series of protocols isn't one protocol short of a load. Should there be a protocol that specifically addresses oil and gas facilities?
I cannot say whether there should be a protocol for oil and gas facilities, but again, I can say that we undertake a pretty extensive dialogue with both the landowners and the other parties that have interest in pieces of property.
Okay. Well, I appreciate your answer. It was a difficult question because it's a difficult problem. And I hear things anecdotally that cause me concern, not about these specific lines. I've heard nothing anecdotally about that. Sometimes those things come to you whether you want them to or not. But I'm just concerned about again, the compatibility of the effective utilization of land by the multiple users of that land, including your company and the other users. Let me change topics here in my last line of questions for you. Rather significant departure from this subject. I'm not suggesting by that it lets you off the hook, however. Are you familiar with the proposed National Transmission Corridor, the so-called NIETC?
I am generally familiar with the concept.
Okay. There's a lot of information out there about this. I'm not so sure there isn't more misinformation than there is information. And it's kind of hard to tell the wheat from the shaft, if we could, out there. I was at a recent conference during the past week. I was attended by some 38 members of the Kansas legislature, and the topic of that conference really didn't have anything to do with this transmission corridor. Yet that was the question that I was being asked most frequently by all of those participants. There have been a number of town halls. There have been a number of community meetings throughout the state. The whole subject is a matter of great controversy, and I think probably because of all the misinformation that's out there, in all honesty. Well, I'm not going to ask you to tackle any definition of what that is, but I'm going to ask you some questions that I would appreciate your responding to, again, for the benefit of the record here and for the benefit of trying to alleviate any possible misunderstandings coming about as a result of the siting of this line. So my first question with respect to this transmission corridor is the proposed Greenbelt project actually within the proposed corridor? In whole or in part?
Yes, the Grainbelt project is within the proposed, I believe, Midwest Plains corridor.
Okay. What implications are there as a result of that?
Yeah.
For the operation of the line, for the interest of landowners, for the interest of all other users?
Yeah, so, Grainbelt is supportive of the corridor designation for the purposes there could be some benefits to project financing, and would note that we have already secured over 97% of the easements for phase one of the line, and we do not have the intention of there being any land use implications or easement acquisition implications for the corridor, particularly not in Kansas, where we're nearly 100% acquired. We have heard a number of we have heard the concerns about the corridor designation, particularly around the width of the corridor, and we've heard, we understand where those concerns are coming from. We do plan on seeking a more formal narrowing of that corridor in the near future.
In what sense? From whom? How would that airing process occur?
I am not an expert in the NIETC process, so I am not able to go into a level of detail about that, but it is our intent to support a narrowing of the corridor in Kansas based on some of the feedback that we have heard, and understand that you all have and others have been taking questions about it.
In the geographic vicinity of southwest Kansas, where your line proposed to be built and where the corridors are proposed to be placed, and realize that corridor process is a multi-stage process, is it not? We're just sort of in the early phases of that. Is that correct?
I believe that is correct.
At least as I understand it. So, as originally proposed, what was the width of the corridor? Do you recall in this part of the state?
I believe the corridor, as proposed, represents a 5-mile corridor width.
In this part of the state?
Subject to check, I believe so.
Is it possible it's 100 miles?
I do not think so.
Okay. We might check that. There are certain parts of the corridor, my understanding was that it is 5 miles. Is 5 miles a lot for a corridor, in your opinion?
I don't know that I feel qualified to say whether it is a lot, but as mentioned, we are supporting a narrowing of that corridor, but I don't know that I can say whether 5 miles is a lot, although I guess you could see how it could be perceived as a lot.
What's the ordinary width of a corridor? Absent being included within this, the purview of this particular corridor, in your experience?
So for these AC collector lines and in general for Grain Belt Express, we are envisioning a 150-foot right-of-way width. But the notification corridor and the corridor that we typically operate in is a bit wider. It is wider than that. For these lines, we notified landowners on 1,000 feet of either side of that of the center line, and that notification really allows us to have more flexibility related to micrositing and design of the line, whereas a very narrow 150-foot corridor just doesn't leave a lot of room for micrositing or flexibility or accommodations with landowners. So, a wider, that justifies that really 2,000-foot corridor that we've provided for the notification, which I think, based on my understanding of recent line siting cases, that 1,000-foot notification on either side of center line is relatively standard practice.
Fair enough. Would you concede that there is one heck of a difference, I'm understating this maybe a little bit, between 1,000 feet either side of it for a combined total of 2,000 feet and 5 miles or 100 miles?
Yes, I think I can concede that.
Question suggests the answer, doesn't it? Okay, my last question for you on this subject is this. And answer this if you can. If you can't, don't.
Okay.
And it's a hypothetical. I'm going to grant counsel that it is a hypothetical. Assuming these corridors are put in place as they were proposed, can FERC override any decision the KCC makes on line siting, including this line siting?
I am being generally unfamiliar with the FERC policies. I do not feel comfortable answering that question.
That's fair. A lot of it's conjectural, a lot of it's subject probably to change without much notice. And what I'm trying to determine here are basically the legal implications of the corridor as it might potentially affect this. And I'm not trying to mousetrap you at all in the slightest. That's why I prefaced the question by saying, if you couldn't or felt uncomfortable answering, don't.
Yeah.
I thank you for your indulgence of my questions. That concludes all my questions of this witness.
Thank you.
Commissioner Keither, any questions?
Ethan, what I had.
Okay. Good morning, Mr. Chandler. I just have one question for you, actually prompted by Commissioner Keene's questioning. I think you mentioned the Grain Belt Express project overall is within the DOE's transmission corridor. Just specifically to this proceeding, are the two AC collector lines wholly within a DOE transmission corridor, proposed transmission corridor?
No, I don't believe so.
Okay, so the specific lines to this proceeding are not within a corridor.
No, it's possible there could be some sort of overlap between, but they're not wholly within, and they were not cited or designed to be part of a corridor.
So your answer was with respect to the DC portion of the line.
That is correct.
Okay, that's all I had. All right, any redirect from Grain Belt?
Yes, thank you. Just very briefly. Mr. Chandler, do you recall a line of questioning from Sunflower's counsel regarding the definition of capital costs that was used in your testimony and in Grain Belt Express's application?
I do.
And in your opinion, are there other costs, such as interconnection costs, that would not be considered capital costs as used in your testimony that would nevertheless be covered by Grain Belt Express?
Be covered by what?
By Grain Belt Express?
Yes, interconnection costs are generally a separate category from development costs, but would be borne by Grain Belt Express.
And is Carlos Rodriguez, would he be the witness who would testify regarding interconnection costs?
Yes.
Thank you. That's all we have.
All right. A little recross from Mr. Zakura.
Are we allowed to have brief requests based on commissioner questions?
I will allow very brief recross, yes.
Thank you. Sorry to say, good morning. I think it's still morning, Mr. Chandler.
Barely.
Just a few questions about Commissioner Cross. I think you said that the national corridors would have some, or could have some financial implications for Grain Belt. Would you expound on that?
Chairman French, I understand that the commissioners did ask questions about NHTSA, but we still would like to lodge an objection. NG has not provided any sort of list of disputed issues in this case. They did not file anything. I apologize.
Just a
I
bit.
apologize. I'll just start over. Okay, thank you. I'll slow down. Grain Belt would like to lodge an objection to NG's questions regarding NHTSA, simply because they have filed no disputed issues list that raise that as an issue, and they have the opportunity to do that. There's nothing, they filed no testimony on the issue. So we do not believe that this witness should be subject to cross simply because the commissioners raised that issue.
Do you need them to spell it, see?
Mr. Zakura, any response?
Yes, please. It's a direct question to a commissioner question. It's limited in scope. It directs also, it also is directly related to the condition of the commission on the certificate and also the AC collector, that the company has to have financial wherewithal to complete a project before it commences. I don't think it's out of bounds, and actually, I think the answer will be favorable to the company.
Yeah, I will allow just a couple questions on the impact of NHTSA designation, but I do agree, based on the disputed issues list, it doesn't seem like there really are disputed issues between NG and Grain Belt Express, and this certainly is not within those that we were aware of. So that's why I would hope that it would be somewhat limited, but it is in response to a commissioner line of questioning, and so I will allow brief questions on it.
I'll be very limited in accordance with your direction. May the witness please answer.
please restate the question. I don't know that I
don't
remember
think
it.
I heard. Sorry.
I'll do my best. I believe in response to Commissioner question, the witness said that the federal corridors could have a financial implication for Grain Belt. And my question was, please explain how the federal legislation and corridors would have a financial implication for Grain Belt.
So again, as stated earlier, I'm not an expert in the NEEC regulations, but it's my understanding that the designations could potentially provide access to favorable or flexible financing options for transmission projects.
May I ask what are the favorable financial options?
You may ask it.
Thank you. What are the favorable financial options?
I am not directly aware of what the specifics of those financing options are.
Then just one further question. You responded to a commissioner question that Grain Belt had 97% of the Kansas easements necessary. Was that only on the transmission line, or did that also include the AC collector system?
So we have over 97% of the phase one HVDC easements acquired, and it's a higher percentage in Kansas. We have not yet begun landowner engagement or easement acquisition for the AC collector lines due to them not yet being approved by the commission.
Thank you.
All right. Since we allowed a little recross, any other parties need to ask a couple questions? Any other redirect? Commissioner questions prompted by anything? Very good. All right, Mr. Chandler, you may step down officially this time. All right. My intention is to go ahead and move toward another witness before we take a lunch break. So Grain Belt, you may call your next witness.
Thank you, Chair French. Although all of the parties have waived cross-examination of Jamie Prech, we would still like to call her to the stand to make a correction to her pre-filed testimony. And we think it'll be relevant to issues going forward. So we'd like to take the opportunity now to make that correction. So Grain Belt Express calls Jamie Prech.
All right. Before you begin, we'll have the witness sworn in.
Do you solemnly swear or affirm testimony you're about to give will be the truth and the truth?
Good morning, Ms. Prech. Would you please state your full name for the record? And by whom are you employed and what is your title?
Can you turn the mic on? And I'm the department manager of the what?
Environmental Studies Group.
Are you the same Jamie Prech whose direct testimony, rebuttal testimony, and testimony in response to public comments and the accompanying exhibits have been entered into the record in this proceeding?
I am.
And do you have any additions or corrections to make to your testimony?
I do.
Could you please point us to where, or I guess which piece of testimony and on which page you're referring?
Yes. To my testimony and the route study, Exhibit JP2, page 22 of 506, most specifically Table 2-6.
I don't know if folks want a chance to turn to that or not, but there is it's the routing study also has numbers at the bottom based on the section numbers. So there is a number at the bottom that's 2-9 within the routing study, if that's easier to find. Okay, thank you. And what is the correction that you have to make to table 2-6?
The correction is for the far right column, critical habitat within the study area, and two specific species listed, the New Mexico thread snake and Plains minnow. Both of those far right columns should state yes, and in parentheses, state.
Okay. And for the clarification of the record, we do have corrected red line and corrected clean versions of that page that we can mark as an exhibit and enter into the record.
Yeah, I think if you would file those into the docket as a corrected version, that would be good.
Okay. And is there a naming mechanism you'd like to use for hearing exhibits?
Whatever you are using, just stay consistent with your exhibits.
We'll do so. And if any of the parties would like a copy, we've got them here. We can distribute them. Anybody need one now before we? Red line. Okay, let the record reflect that I've handed out copies of the red line and clean versions of the corrections you just described. Does that, do those changes affect your ultimate analysis as stated in the routing study?
No, it does not.
And do you have any other additions or corrections to make to your testimony at this time?
I do not.
Okay, with that, because the testimony has already been admitted into evidence, I have no further questions.
All right, thank you. And I believe every party and the commissioners have waived examination. So, Ms. Prech, you may step down.
Thank you.
Thank you. Grainbelt, you may call your next witness.
Grainbelt calls David Gelder.
Go ahead, whenever you're ready. Oh, and make sure your microphone is turned on with the blue light. There you go.
Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
I do.
Good morning, Mr. Gelder. Please state your full name for the record.
David Gelder.
And please state your employer and your title.
I work for Evidentiary and I am a senior engineering manager.
And are you the same David Gelder whose testimony has been admitted into evidence in this case, which includes direct testimony, rebuttal testimony, response to public comments testimony, and rebuttal testimony in response to public comments?
I am.
And do you have any corrections to that testimony?
One minor correction.
And could you please direct us to the testimony and page that you're referring to?
In my direct testimony, page 3, line 15, strike the Maverick 138 kV transmission line in Oklahoma.
Okay. And with that correction, if I asked you the same questions today, would your answers be substantially the same?
Yes.
Okay. And since the testimony has already been admitted into the record, no further direct examination questions, and the witness is available for cross.
We will then turn to the list of cross-examiners that I have. I have the Boyds first, but you have waived examination. Mr. Zakura, does NG have any questions for Mr. Gelder? Sunflower, I believe you did indicate you have questions.
Morning, Mr. Gelder. How are you?
Good.
Just want to ask you a few questions about your testimony. Do you have a copy of your testimony with you?
I do.
I'd like to point you to your rebuttal testimony, which was filed July 26th, 2024. Going to start on page 6. Just let me know when you're there.
I'm there.
I'm looking at lines 2 through 6, where you're talking about performing an induction study. When do you plan on performing that induction study?
Yes, so regarding the induction study, that will require coordination with Sunflower. There are inputs that we will need from Sunflower that we would not be able to perform the study without. In terms of timeline, it's something that we would probably perform in the next 6 to 12 months.
Okay, so you don't have all the information today to perform the study.
That is correct.
So then it would follow that you can't definitively say today that paralleling of Sunflower's line by the AC collector system will not require any mitigation solution?
That is correct. I cannot say definitively whether or not it will require mitigation.
In this proceeding, will the commission have to make a decision on the reasonableness of the location of the AC collector lines? I'll move on. Let me just ask my question a different way. Will the induction study that we just referenced not be performed until after the commission makes a decision in this docket?
I'm not sure on the exact timing.
You're not sure on the timing?
I'm not sure on the timing of those two different events.
Okay. I'd like to just point you back to page 5. I'm looking now at lines 17 through 20, where you're talking about mutual induction, and you state that to the extent additional mitigation is necessary, there are effective options available. Could you explain what those options are?
As stated in the follow-up question, what actions is Greenbelt Express taking to mitigate these concerns? On line 24, it says Grain Belt Express believes the effect of mutual induction will likely be mitigated by the current proposed line separation. In other words, centering the proposed Meade to Dodge City line within the 150-foot right-of-way while bordering the existing easement. However, Grain Belt Express plans to perform an induction study to quantify the change in impedance and to evaluate the impacts of changing the separation between the lines. In other words, it's possible that additional line separation may be required.
Are there any other effective options that you've identified today?
There are other options that would be the preferred. Other options may require changes to either line.
Potentially an option to mitigate the issue could be a change to Sunflower's existing line.
It's possible.
Is the purpose of the induction study to identify potential issues and mitigative solutions?
Correct.
Who would pay the cost of those mitigation solutions?
Again, the primary mitigation proposed by Grain Belt Express would be additional line separation between the two lines. It is my understanding that additional costs may be borne by Grain Belt Express as needed. However, again, the primary mitigation will be to simply further separate the lines.
So it's possible that Sunflower could bear the cost of those mitigation solutions?
I'm not an expert on cost allocation. But I believe Grain Belt Express intends to work with Sunflower, and to the extent that Grain Belt Express causes additional impacts related to this study to the line, those costs would be primarily borne by Grain Belt Express.
Primarily borne, but not exclusively borne?
Again, the study hasn't taken place, and if there are other costs that are required that are not imposed by the introduction of the Grain Belt Express line, those costs we would not be responsible for.
But if a cost is introduced by the Grain Belt line, would Grain Belt be responsible for that cost?
Yes, again, if that could not be mitigated simply by additional line separation.
No further questions. Thank you, Mr. Gelder.
All right, thank you. Does commission staff have any questions of this witness?
Staff has no questions.
All right. Brings us to commissioners. Commissioner Keen, do you have any questions of this witness?
No questions, thank you.
And Commissioner Keither? I have maybe just one question. I'm a little confused about this induction study. and maybe this is a question for Mr. Rodriguez, and if you want to defer it, that's fine. Is this induction study wholly separate and a private undertaking between Grainbelt and Sunflower? And is it wholly separate from the interconnection process within the Southwest Power Pool?
That is correct.
Okay, so there is no, if there is an outcome where investments are needed, there is no in-place mechanism for the assignment of those costs.
I'm not aware of those mechanisms.
Okay. All right, that's all I have. Any redirect?
No redirect.
Okay. All right, Mr. Gelder, you are done and you may step down.
Thank you.
We are almost at noon. I suspect your next witness will have a good amount of questioning. Would you all like to get started with our next witness, or would you like to take an earlier lunch break and come back? Is there any preference? I'm looking at Grainbelt.
We can certainly start with his direct exam and then he'd be ready for cross after lunch if that's acceptable.
It's fine. All right, go ahead and call your next witness.
Thank you. Grainbelt Express calls Carlos Rodriguez to the stand.
There you go.
Thank you.
Sir, will you raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth?
Yes.
Good morning.
Morning.
For a few more minutes only, it is morning. Would you please state your name for the record?
Carlos Rodriguez,
And by whom are you employed and what is your title?
Invenergy, Senior Vice President, Interconnections and Grid Analysis.
And are you the same Carlos Rodriguez who filed rebuttal testimony in this proceeding?
Yes.
Do you have any additions or corrections to make to your testimony at this time?
No.
If I asked you the same questions today that are contained in your rebuttal, would your answers remain substantially the same?
Yes.
I have no further direct questions and would tender the witness for cross.
All right, I'm going to take a risk here. I'm going to go ahead and see if we want to start with Mr. Rodriguez. And we'll just hope that we can find a good stopping point in the next 30, 45 minutes, something like that. So the Boyds have waived cross. NG, do you have questions for this witness?
Just a few.
Okay, go ahead.
Good morning, Mr. Rodriguez.
Good morning.
I'm Jim Zakora, counsel for NG. Have a few questions for you, sir. In your study, you have referenced, in your testimony, you referenced two types of study. And I believe, would that be correct? Two studies are going to be undertaken with regard to the Southwest Power Pool that are ongoing.
Not two, three.
Okay. I stand corrected. Please state the three studies that are ongoing.
Well, one study has been completed
Okay.
and two studies are ongoing.
Okay.
Or one study ongoing and the other one pending.
Well, let's move on from the one completed and speak to the two that are pending.
Yeah.
Okay, please, would you describe those?
Yeah, so the two studies are part of the Southwest Power Pool process that a transmission line connecting to the SPP system needs to follow. Those studies or the process consists of three studies: the feasibility study that has been completed, the planning study, and the design study. So the design, the feasibility study is just a first pass at the project. It has been completed. It's mainly power flow analysis, a little bit of dynamic analysis. The planning study goes more in depth into the power flow, the short circuit, and the dynamic analysis. And the design study, which comes later, then goes in full detail, simulating electromagnetic transients with models that are developed by the original equipment manufacturers, or in this case, Siemens, and also detailed models of the grid elements. So that's a main description.
And would you state for an overall purpose, what is the overall purpose of those studies? Is it the impact of grain belt on Southwest Power Pool operations? Or could you state it more specifically, sir?
Yes, basically the idea here of all these studies is to assure or ensure a reliable interconnection of the grain belt project to the Southwest Power Pool system in order to meet or exceed the established planning criteria.
And where would the interconnection be that you're speaking of?
When it meets the planning criteria?
No, what the location of the interconnection? Are you, this is studying on how it is it an interconnection with SPP or, okay, where would the interconnection be is what I'm trying to say?
Yeah, it's the interconnection is to the existing ITC saddle 345 kV substation.
Okay. And if there are costs determined by SPP, what kind of costs might those be?
So it could be costs to mitigate issues that are found in the studies. Could be if voltage issues are found or any other disturbances that could cause oscillations, power oscillations, those would be identified and they would be mitigated by grain belt.
Have you at all done any preliminary studies that would indicate whether or not mitigation would be needed? And if so, how much that cost would be?
So we have not gotten to that point yet. We have done the feasibility study, which indicates that the project is feasible. From an electrical perspective, this study was presented to the SPP Transmission Working Group, the TLUG, and it was accepted, which allows us to go now to the next phase. Nothing was found in the feasibility study that would point at the project having any major issue.
Let me please ask you, sir, when was that study presented to SPP?
I believe that was it May 2023?
Okay.
I'm not sure, I'll have to check. But it was a while ago.
In researching this project as best I could at SPP, there were studies that began far earlier on that. I saw some in 2016. Are you familiar with those?
Yes.
Okay. And what were the purposes of those studies?
Okay, so the project, before the project was using a different high voltage DC technology that is called line commutated converter. It was 4,000 megawatts. That project went through the TWG process and got to the interconnection agreement. So those studies were completed with a different technology. We are changing that technology to a more modern HVDC technology that is called voltage source converter, which is basically what most HVDC projects are being built today. So therefore, we are redoing the studies with a new technology.
Sir, may I ask you, does this study relate to only phase one, or does it relate to the phase one and phase two project of grain bale, the full 5,000?
It would be the full 5,000.
I would please like to direct you to page 8 of your testimony.
Page?
8, please. And I am please direct you to page 9 and, lines 9 and 10. And in your testimony, it says the design study is performed by the HVDC customer's vendor in close collaboration with SPP. And I think you make that distinction otherwise. Tell me why that is not done by SPP and why it's only done in close collaboration.
So the TWG studies, the SPP TWG studies are not done by SPP. So the procedure indicates that the customer, in this case Grain Belt, does the study, and the study is subject to review by SPP and the affected parties. So Sunflower and all the other utilities that are part of SPP would basically participate in defining the scope of the studies. So, for example, the feasibility study was approved with input from all affected parties. The same thing, the planning study, the same thing will happen with the design study. The difference here is that for the feasibility and the planning, we are using a consultant, but for the design study, we're going to use our OEM, Siemens, to do detailed studies with their detailed model as designed. So they would be the best suited to do that.
Can you, sir, give me an estimate of time on when the studies will be completed?
So we expect the planning study, the one that is ongoing, to be completed by the end of this year. And the design study would be completed probably second half of 2025.
Now, were you in the room earlier today?
Yes.
Okay. Let's line those up with what I think your colleague said, that construction would, he hoped to begin, I think he said in the last half or last quarter of 2025. Does that line up with what you're saying as far as the completion of the studies goes?
Yes.
Let me ask you, since this is since ultimately you will be interconnecting into MISO and Associated Electric, and I guess ultimately even PJM, do those RTOs review any of this, or do they have a part, or do they require a study?
So we have already executed interconnection agreements with an effective interconnection agreement with MISO and an executed interconnection agreement with ACI. And with PJM, phase 2 is in the PJM queue, is undergoing what we call the transition cluster 1, which has finished the first phase. So they are all doing studies in order to get to interconnection agreements in each of the terminals.
Is there anything ongoing, or is there a requirement of either MISO, AES, Associated Electric, ACI? Is there anything with regard to their study or interconnections that could foreseeably delay the commercial operation of the project?
Not that I foresee.
So would it be accurate, sir, based on your colleague's testimony earlier, that any requirements of SPP, MISO, AECI would be completed so that commercial operation, I believe he said, could commence in 2029?
Correct.
Thank you. I have nothing further.
All right. Sunflower.
Good afternoon, Mr. Rodriguez. I guess it is afternoon now.
Hello.
It's good to be speaking with you. I know we've spoken on the phone, so it's good to be with you in person. On behalf of Sunflower, we really appreciate your willingness to collaborate and discuss these issues with Dr. Tamimi. And I've been on some of those phone calls. I'm not going to try to go toe-to-toe with you on transient impact, I promise you. But I do have some questions for you, so if you just indulge me. And bear with me a little bit because Mr. Zakura took some of my questions here. So in the interest of efficiency, I'll try to skip those that have already been asked. Do you have your testimony with you?
Yes.
Could you just turn to page 6, please? I'm really looking at lines 11 through 15, and this is kind of back to the studies that will be performed. You list a number of studies. We just confirmed that the feasibility study has been completed, but I'm looking at now page 12, lines 6 and 7. I just want to confirm the feasibility study does not address the specific concerns of staff and Sunflower regarding power quality?
Correct.
Okay, thanks. Then I'm going to flip you back to 6. Sorry, I'm jumping around, but just for some clarification, you mentioned 3 studies, but I'm looking at lines 14 and 15. You list a number of studies: steady state studies, short circuit studies, dynamic studies, electromagnetic, transient studies, harmonic studies, and control interaction studies, among others. So for clarity, which are all of those studies included within the 2 additional studies that are remaining?
Correct.
Okay. Are those studies required by SPP?
Yes.
Okay. Are those studies fairly extensive and detailed?
Very extensive.
Do they take a significant amount of time and effort?
Yes.
Are they costly?
Yes.
Would you define these studies' cost as de minimis?
Not sure what you mean by de minimis.
Just exactly that, de minimis.
Not sure I understand the question. Like in which context? Like I don't understand.
I'll move on. Just to confirm the time frame on the studies, all of the studies that you've referenced that SPP will be completed, will those not be completed until after the commission makes a determination in this docket?
I know the timing of the studies, but not the timing of the commission determination. So
What is the timing of the studies, just again for the record? When will they be completed?
the studies, the expectation is the planning study to be completed by the end of '24,
Okay.
and the design study to be completed by middle to second half of '25.
Okay, thank you. And I apologize. I know Mr. Zakir had already asked you that. I'm going to turn now to page 11 of your testimony. And I'm looking at lines 3 through 8. Let me know when you're there.
Okay.
Okay, you state that retail electric customers in Dodge City area are not at risk of losing power if Grain Belt goes out of service. Do you have a study that has concluded that?
So that's what the planning study is going to show, and that's what the design study is going to show. So we're going to do an extensive set of simulations to guarantee, assure that the project meets with all the SPP planning criteria, and therefore it can operate within that criteria, which would mean that in the case of a fault or a disturbance, the customers would not be negatively affected.
So you're saying the study to examine that issue has not yet been completed?
Correct.
In lines 5 through 8, you talk about appropriate protection systems and any additional mitigation that may be identified in those studies. I think it's fair to say that you have not today identified any appropriate protection systems and any additional mitigation. Is that correct?
After the first study, the feasibility study, we haven't. The planning study and the design study will identify protection requirements so that if there's a disturbance that affecting grain belt, it could be quickly eliminated without affecting the SPP system, negatively affecting.
So the studies that you plan on doing will identify whatever mitigative solutions are necessary?
Correct.
Is it possible that those mitigation solutions will be installed on grain belt facilities?
Some of them could.
Is it possible that some of those mitigation solutions could be installed on sunflower facilities?
Yes, some could.
Is it possible that some of those mitigation solutions could be installed at the distribution level?
Very unlikely. I don't think so.
And I understand the studies haven't been done, and I know I'm just asking whether or not it's possible. In your opinion, who would bear the cost of the appropriate protection systems and any additional mitigation that's identified by the studies?
That would be grain belt.
I'm going to point you to page 12 now. And actually, Mr. Rodriguez, I'm going to let you off the hook. No further questions. Thank you.
Thank you.
All right. Does KCC staff have any questions for this witness?
We do not.
All right, then we will move on to commissioner questions. Commissioner Keene, do you have any questions?
Good afternoon, Mr. Rodriguez.
Good afternoon.
Your biography is impressive. And I know that certainly in terms of technical issues, I think that's certainly your forte, but I think your background in terms of senior level management positions you've held shows quite a variety of experience to me. Were you present this morning during my cross-examination of Mr. Chandler?
Yes, I was.
Do you recall a part of that colloquy that I had with him pertained to some protocols that had been established in setting ground rules, if you will, for communications and dealings with landowners?
Yes.
Have you been a part of the process in the past, or are you familiar with such protocols?
I am not.
You have not been a part of the development of those in the past.
No,
Are you familiar with those protocols?
I am not. So I'm mostly focused on the electrical side.
Okay. No further questions.
Commissioner Keither, any questions?
Just a couple, just to clarify. Good afternoon. I have in front of me the map of phase one and phase two of the project, which says begin construction activities in 2025. And you're saying that your planning study will be finished by the end of this year?
Yes.
And design will be done by the end of 25. So when does the actual construction begin?
So we expect studies to be completed by the middle of 25. I don't manage the construction side, so I'm not sure exactly when construction is going to start. I believe it's sometime late in 2025, but the expectations is for the studies to be completed by then.
By that time? Okay, thank you.
Good afternoon. I want to beat a dead horse a little more, so if you'll indulge me. I want to go back to the issue. I know you were here when I was speaking with Mr. Gelder, and we talked about, there's these two different pathways of studies. There's a sort of a private induction study going on between Grainbelt and Sunflower that's not part of the SPP process, apparently. And there are still the planning and design process within the interconnection process, and that is ongoing in the SPP process. And we also explored the fact that there is not currently an agreement for how any upgrades or mitigation costs would be allocated in that induction process that's not part of the SPP process. But I believe you testified to Mr. Calcara with Sunflower that there is a set assignment of costs if upgrades are identified in the interconnection process at SPP, correct?
Correct.
Okay, so that's one difference. Can I ask why this separate induction study is not part of the SPP interconnection process? Is it just that it is so local and remote from the SPP system, or what is different about that it would not be captured in your feasibility study or your planning and design studies?
Yeah, so the SPP studies are mostly what we call power system analysis studies. So it's simulating the grid, disturbances, contingencies, making sure that everything works. The study, the mutual induction study, is more of like an engineering study rather than a power system analysis study. It's smaller scale, so it's not part of the set of power system analysis that SPP has defined in the scope. It would be more of an engineering study that would be outside of the SPP power system analysis combo, I would say.
Okay. And I apologize. I know you're kind of the interconnection witness, and we've already had the transmission planning witness. I'm just trying to drill down on how this would play out from a business standpoint if there were some upgrades needed as a result of that induction study. I mean, all we have in Mr. Gelder's testimony is they look forward to working with Sunflower on that. Do you have anything to add, or we'll absolutely accept if you say this is outside of the scope of your testimony.
Well, if there is an impact on the sunflower system due to induction of one of our lines, we would identify the mitigation, and given that it's due to our project, that specific mitigation, we would cover it.
Okay.
Or we would pay for it. I mean, if sometimes happens that a study identifies a mitigation, and then the utility wants to make the mitigation, but then, well, now that I'm doing this, I wanna, right? We've seen that.
Mhm.
So we would cover the mitigation to mitigate the mutual induction issue. However, nothing beyond that.
Yeah.
Right? So that would be the.
I appreciate that. It's a very candid answer. I have nothing further. Any redirect?
No redirect.
All right. Mr. Rodriguez, you may step down. Thank you for your testimony.
Thank you.
All right, we're at 12:20. This seems like a perfect stopping point for lunch. Mr. Flaherty?
Yes, thank you, Mr. Chairman. Because the commission doesn't have questions for Mr. Boyd, I wanted to see if I could get them excused so they can make an early trip back home.
Yes.
Great, thank you very much.
That's great. Safe travels. All right, so with that, it's 12:20. When we come back, we will resume witness examination. Let's plan to be back at 1:15, if that works for everyone. So we are off the record, returning at 1:15.
Chair French, just one question. Is Dr. Al Tamimi the next witness that's up? Just for clarity, so I can communicate with him to log into the Zoom?
Yep, on my list it is, unless Grainbelt is not planning to bring up any additional witnesses for corrections or anything, correct?
No, we
Okay.
don't have any further witnesses to call.
I
Yep,
will-
Dr. Tamimi will be next.
At 1:15. I will
1:15.
instruct him accordingly. Thank you.
All right, thank you all.
I don't know how it happened, but somebody pointed it out to me. Like, you almost did.
All right, be seated, everyone. All right, I believe we were ready to resume the examination of witnesses, and I think we were with Sunflower. So, Mr. Calcara, if you would like to call your witness.
Thank you, Chair French. Sunflower will call Dr. Al Tamimi, who is present by Zoom. I see him on the screen.
All right, we see you. Dr. Tamimi, do you want to test your sound real quick? Can you hear us? Dr. Tamimi, can you hear us? You may be double muted. Or your speakers are muted. All right, let's go off the record for just a second. Mr. Calcara, why don't you call your witness and see if you can get him connected in here. We're off the record.
Hey, Taylor.
Oh, we can hear you now, Al. Can you hear us?
Do you hear me now?
We hear you. Can you hear us?
Yeah, I hear you. The problem is my laptop. Do you guys hear me now?
We do hear you. How's the sound on your end? Can you hear us, Al? We do hear you.
I can't hear you.
Okay, we're going to go off the record. We're still going to stay off the record.
Do you hear me now?
We
I
do
think
hear
you
you.
hear me, but I can't hear you.
Yes. Michelle, could you please stop the live stream for a moment while we resolve our technical difficulties? We're off the record.
Okay, I'm gonna try my cell phone real quick.
All right, Al, can you hear us now?
Yeah, I hear you. Just a second.
Left off.
I think you'll need to
I think you called him. Okay. All right, we are back on the record and we are ready for the witness to be sworn in. So I will turn it over to the court reporter.
Sir, will you raise your right hand for me?
Yeah, I hear you. Just a second.
Left off.
I think you'll need to swear.
Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right.
Thank you, Chair French. Dr. Tamimi, could you please state your name for the record?
Yeah, Al Tamimi,
Could you please state your employer?
Sunflower Electric,
Could you please state your business title?
COO of Transmission.
Are you the same Dr. Al Tamimi that filed direct testimony in this docket on July 3rd, 2024?
Yes.
If I asked you those same questions today, would your answers be the same today?
Yes.
Okay, thank you very much. I would tender the witness for cross-examination.
All right, thank you. I don't believe the Boyds have any questions for Mr. Tamimi. Does NG have any questions for Mr. Tamimi?
No questions, please.
Greenbelt.
Yes, thank you. Dr. Tamimi, can you hear me okay?
Yeah, I do.
Okay, fantastic. Thank you. I'd like to refer you to page 7 of your direct testimony, please.
Okay.
And I'm looking specifically at lines 19 through 21. Just let me know when you're there.
Okay.
Okay, so lines 19 through 21, you say that Sunflower will need to study these issues to determine their extent. When you talk about studying the issues, what studies are you referring to?
Well, the studies of the interconnection of the Greenbelt Express to the ITC facility at Saddlehorn. At this point, we believe that there will be some studies done in the SPP arena. However, there's another study that we refer to the EMTP study, electromagnetic transient program, that is required to be done to make sure that those technical studies identify the impact on our system.
So the studies you're referring to, they're not the same studies that are referred to in Mr. Rodriguez's testimony that will go through the SPP study?
What does
I
he
beg your
have in
pardon.
his testimony? What does he have in his testimony? What study
He references the SPP's planning, feasibility, and design studies.
Yeah, those are required by SPP, but if you're familiar with the SPP process, any interconnection 300 kV and above, there's additional study work that is needed, and we believe there's study work needed above and beyond what SPP requires.
What are the differences between the studies that Sunflower believes are required and what will happen through the SPP TWG process?
Yeah, the SPP TWG process focuses on two types of study. One of them is what we call steady state analysis, which is a power flow analysis, and also the transient study. However, in the SPP criteria, I think trying to remember what section is that, section 14.3, it talks about additional studies that the affected party will determine if needed or not needed. SPP is not going to trigger those studies. Affected party can't trigger those studies, but they have to agree that those studies are needed to bring them in to SPP. SPP is not automatically going to say, oh, go do these studies that I'm referring to.
Yeah, I'm sorry, Dr. Tamimi, you cut out in the middle of that answer.
SPP studies has two studies that are required. However, on the 345 kV and above, SPP allows the affected party to bring additional studies to the SPP, but to bring them to the SPP, the parties need to agree to bring them to the SPP. SPP does not require them. And that's what I'm after here, is to talk about those additional studies needed.
And Dr. Tamimi, Sunflower is an interested stakeholder in the SPP process that will interconnect Grainbelt to the SPP system. Is that right?
Yes.
And as an interested stakeholder, could Sunflower bring those to SPP and request that they be included within the scope of the studies?
Only if the affected parties agrees together. So if Greenbelt expressed, so we don't agree with you, I can't bring it to SPP.
But if Grainbelt does agree, then you could include it within the scope.
Yeah, I could include it within the scope if they agree and we go to SPP together and nobody oppose it. Because when you go to TWG, there's 21 or 22 members. Actually, now it's a lot more. They will take a vote and they could vote yes, they could vote no on TWG.
Dr. Tamimi, why, in your opinion, would they vote no if a study is required?
There's still a possibility. I don't know why. You never know what comes up.
Dr. Tamimi, the scope of the SPP studies is rather extensive, is it not?
That's your opinion. Depends on the interconnection.
But is it not true that Sunflower could propose changes to the scope as an interested stakeholder?
We could propose. It doesn't mean it's guaranteed that they're gonna take it and do it, or allow us to do it, or allow even. Yeah, that's the extent of it. There's no guarantees there.
Excuse me. Have you requested that these extra studies be added to the scope?
At this point, we've been talking to Carlos and from Great Bell GPX, and he indicated that they're willing to do the studies. But again, it doesn't mean we're going to agree on everything to take to TWG. So at this point, there are some communications that we are intending to do those studies.
Why wouldn't we agree? It makes sense what he proposes, unless he proposes something.
Do you have reason to believe that Grainbelt Express would not agree to include the studies that you're requesting?
Based on verbal communications with Carlos, he was welcoming, he was understanding. However, there's nothing in my hand that I say 6 months from now this is going to happen.
All right, thank you. We have nothing further.
Thank you.
All right. Does KCC staff have any questions for Dr. Tamimi?
We do not.
Okay. Well, then we are moving on to questions from the commissioners. Commissioner Keen, do you have any questions?
No questions, thank you.
And Commissioner Keither? Oh, I can't let you have no questions from commissioners. Maybe I need to drill down on this issue of the studies a little more to make it either clearer or much more convoluted in my own head. And unfortunately, I'm reading your testimony on my smartphone, so bear with me. I've got a huge ream of paper here and somehow yours is not in it. So it looks to me like you identified, if you're on that page 6 of your direct testimony, July 3rd, you've identified really three issues. The first deals with the impact on your system and the power quality due to transient events. The second is the issue of the transmission system being considered a weak system with little inertia around the Dodge City area. My understanding of Mr. Rodriguez's testimony and response was that those first two issues would be included in the SPP study. Do you disagree with that? That those first two issues would be included?
So Mr. Commissioner French, what I'm referring to, flicker voltage dips, we're talking about weak system with low inertia. Yes, a lot of them will be looked at in the required studies. However, some of those issues are transient in nature, and to truly look at the actual voltage fluctuation and the actual flicker and things like that, you need that extra modeling to make sure that you're looking at it from the truly transient perspective. So some of it will be captured, but not to all extent. I don't know how to explain that better.
It sounds like you're saying it's a matter of scope, that the issues would be addressed, but you're concerned that the scope of those studies might not be comprehensive enough. Does that capture what you're saying?
Yeah, that's correct, which will require a whole new study because you have to detail more detailed models. Am I right? We have to detail all the wind farms around the city. We have to detail generation resources. We have to detail above and beyond what the required transient study that SPP does to make sure we see the true oscillations and things like that. Remember, we do have a lot of sensitive loads in city of Dodge City, like Coke Industries, National Beef, and those type of power quality issues can actually knock them off. And when they knock them off, it's hard to bring them back on instantaneously. It could be damaging to their operations, which will require mitigation. And I want to make sure I'm not chasing my tail 2 years later that I'm trying to mitigate, those situations.
So let's follow this thread a little bit. I guess I'm hearing that Grainbelt, at least in your communications with them, has been open to getting the scope right from your perspective, but you're not sure. So what if it moves forward through the SPP process, the studies are not comprehensive enough in your view? What's the venue for challenging that? What options do you have available if you don't think that the interconnection that results from that, or the I guess lack of upgrades, what's your next venue?
I think my next venue is talk to Grainbelt Express and say, here's the additional study that we've done. I think I talked to Carlos about agreeing with him to use the same models that SPP has. This way we're not coming up with some fictitious model. We'll just use the same models that they use in the SPP arena to build those more detailed cases. Then we will analyze them and we'll present the results to Grainbelt Express to get their input on those. And then eventually, if we both agree, then we could take it to TWG for their review. Am I right? But the problem is I can't take it to TWG unless Grainbelt Express agrees to allow me to go to TWG and present it because they're the interconnection.
I guess
so
I'm
that's
looking a
where the
little.
difficulty.
My apologies. Go ahead.
No, I'm done. I'm good.
I'm just looking a little farther down the line. I guess I'm assuming an even worse case scenario. What if Grainbelt does refuse to expand the scope with you? what if TWG disagrees with you, goes ahead and approves the studies, ultimately, they've got a signed generator or interconnection agreement. What's your venue to challenge that? I mean, do you file can you file a complaint at FERC? Is there a challenge process through the SPP stakeholder process?
I will tell you, if I get to that point, I gotta have to fix the problem regardless, because you worry about the end user, am I right? So they can't wait till I go and challenge whatever I challenge. I have to find a solution for it. And the solution could be, what we call static VAR compensator installation or converting Fort Dodge to synchronous or something, am I right?
Mhm.
And then I will go to SPP, but the problem is with SPP criteria, I'm prohibited to bring it to them because Greenbelt does not want it to bring it in. I'm not even allowed to take a vote at it. But even if me and Greenbelt Express agree and we go to the TWG and TWG refuses to take care of it, my case is done until I go to FERC and file a 206 filing. There's no other venue for me to do anything at this point.
Okay. And just one final confirmation question here. I was on this page 6, take you back to page 6 of your testimony. I mentioned that those first 2 paragraphs seem to be encapsulated in the SPP, potentially within the SPP interconnection study process. Then the third paragraph that begins on page 6 and continues on, this is the potential mutual induction study, and that is, and you agree that is outside the SPP study process, correct?
Yeah, let me read it. This is the third. We are assuming the ACC collector line. Is that the one?
Yes.
Yeah, this is outside of the SPP process.
That is just something you will work on
We'll have to
privately
figure
with Greenbelt.
Yeah.
Okay, I think we're all clear on that. I'm not sure we're all clear on exactly what's going to happen with the first 2 items. So, but I do appreciate your answers. Good to see you, Dr. Tamimi.
Thank you, Commissioner. Appreciate the committee.
Any redirect, Mr. Calcara?
No redirect, Chair French.
All right. If there is no recross, Dr. Tamimi, we thank you for your time. You may virtually step down.
Thank you.
All right. With that, we have come to our final witness. Staff, you may call your witness.
Staff calls Paul Owings to the stand.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Good afternoon, Mr. Owings. Good afternoon, Mr. Owings. Would you please state your full name and title for the record?
Paul Owings. I'm the Deputy Chief Engineer at the Kansas Corporation Commission.
Are you the same Paul Owings who caused to be filed in this docket direct testimony on July 3rd, 2024, testimony in response to public comments on August 7th, 2024, and responsive testimony on August 21st, 2024?
I am.
Do you have any corrections to make to any of the aforementioned testimonies?
I do not.
If I were to ask you the same questions today as those contained in those testimony filings, would your answers be the same?
Yes, they would.
Thank you. Staff presents the witness for cross-examination.
All right, thank you. The Boyds, I assume, have no cross-examination. NG.
Good afternoon.
Oh,
Good afternoon.
Sorry, I turned the mic off.
Good afternoon, Mr. Irons.
Good afternoon.
I'm Jim Zakora on behalf of NG, and I have a few questions for you, please.
Okay.
I would direct your attention to, well, it's actually footnote 3 of the application. And let me just summarize for you rather than turn to it. In the discussion earlier, were you in the room today during the morning's discussion?
Yes, I was.
And did you hear the testimony of the Greenbelt witness to the effect that any parties that wanted to connect or interconnect into the line would be treated in a fair and equitable basis? Did you hear that testimony?
Yes, I did.
And would that be the staff's expectation that all renewable generation developers out there would be treated equally with regard to the chance to be a part of the Greenbelt Express?
Yes, and I'm thinking back to a data request. I believe they said they would follow the open access tariffs. So I think that in response to that data request, I guess we were okay with that response from Greenbelt.
Okay. Now, my questions are limited to the list of disputed facts to give you some frame of reference, sir. Earlier in the testimony, there was discussion from the Greenbelt witness as to what precautions would be taken, protocols with regard to building the AC collector lines. Were you in the room for that testimony?
Yes, I was.
And would it be your expectation on the part of staff that the parties would cooperate in a reasonable manner to accommodate whatever construction is being done?
Yes, and Greenbelt is a regulated utility, and NG, I don't believe is, but we would generally anticipate coordination on those efforts.
Okay. Now, let me get to what I consider the main part of the disputed issues and which the staff is a part of, and that's the master plan for the AC collector system. As I understand the pleading filed, it's the expectation of staff that a master plan for the AC collector system will be prepared by Greenbelt. Is that correct?
Yes, that's correct.
And there is a provision, isn't there, that the master plan can be changed? Is that also correct?
That's correct.
And what kind of set of circumstances can you envision that the master plan would need to be corrected? Would there need to be more volume attached, or what kind of circumstances would you see that come up?
We've discussed this, and I think that we wouldn't anticipate significant changes to the master plan. I believe the requirement was they submit a master plan 90 days before the next line siding filing, and then if they would like, they could revise that master plan and submit it with the following filing. We just would anticipate minor revisions to that master plan at that point.
Okay. And let me see. I think that if I recall correctly, and you'll need to correct me if I don't, but wasn't it the testimony this morning that the AC collector lines were not within the national interest transmission corridor?
I believe at the converter station, there's a little bit of overlap. And then I think the Plains Southwest overlaps the southwest section, but a majority of the AC lines are not in the NEEDC corridors, the preliminary corridors.
So the sense of my question is, as far as the AC master collection system, the Kansas Corporation Commission would have primary jurisdiction over the master plan and AC collector system. Would that be correct?
That's my limited understanding of the NEEDCs and how they work with FERC.
Okay. Let me please move on to another part of that. I believe that in the list of disputed issues, you have made it a condition of the certificate if I understand correctly, that there'll be no construction of the AC collector system until there is a renewable energy developer who has signed on to be a part of the system. Is that correct?
That's correct.
And may I ask you what your thinking was with regard to the advocacy of that particular condition?
When I considered the reasonableness of the line in my July 3rd direct testimony, I considered as a part of that the start points of the Buckland and Meade lines. And we did a data request to GBEE, and they indicated the start points were based on potential interconnect agreements. So since the agreements were only potential, we thought a condition to require interconnects prior to constructing the line would be prudent.
Let me drill down on that a little further if I could. Would it be fair to say that it would be in the best interests of Greenbelt, of the resource developer, of the KCC, of the landowners, that there be some certainty in the connection and operation of the line before major construction begins?
Yes, that was the intent, to protect the landowners. And that also relates to the requirements with the easements and those dissolving should they not construct the line. So we put those conditions in place to protect the property owners, or we recommended those conditions, excuse me.
Okay. And let me speak to that point a moment, if I could, where you talk about easements that are obtained by, I believe, eminent domain. Is that correct?
Yes.
Okay. And you have a particular condition about that, those easements. Would you reflect what that condition is for the record, please?
On the eminent domain easements, they would dissolve after a certain time period should the lines never be constructed.
Okay. And I'm trying to parse through how the KCC staff would moderate that, or not moderate, look at whether or not that was being done. Do you anticipate some kind of compliance filing or some type of filing that would designate which of the easements were obtained through eminent domain?
I hadn't really previously contemplated that, but it would probably be beneficial to track that, yes.
Okay. In terms of the condition that you have, that you're recommending for there to be an interconnection of a renewable energy developer to the system before it begins, do you have within your recommendation, is there any quantity restriction or limitation or requirement? And do those or any of those type of agreements need to be filed with the commission?
We didn't specify a minimum quantity, and if it is a condition that they have to have an interconnect prior to construction, I would think they would prove that with a filing.
Okay. And I believe the final question I have is on the various conditions, which certainly our client supports, do you anticipate there to be a compliance filing of any type to the commission? I believe Greenbelt does a quarterly compliance filing presently, but on these new sets of conditions that you are proposing, do you anticipate there to be a compliance filing?
I think on some of them there was compliance filings and on others there weren't, if I recall correctly.
Okay. And you know what? I believe that's all I have. Thank you for your testimony.
Thank you.
All right, Sunflower, do you have any questions?
Am I on now? Good afternoon, Mr. Owings.
Good afternoon.
Just like to ask you just a few questions. I am looking at your direct testimony that was filed July 3rd, 2024. Do you have that in front of
Yes,
you?
I do.
I'm on page 15. And I'm on lines 12 through 15. Are you with me?
Yes.
You're discussing power quality issues, and to the question of who should fund the costs of mitigating power quality problems, your answer is, should mitigation measures be required, retail ratepayers in Kansas should not be responsible to pay for mitigation measures. Staff recommends Grainbelt Express pay for mitigation measures, therefore passing the cost to entities who directly benefit from the GBE project. Is that still your position today?
Yes.
Mr. Owings, were you in the room this morning when I referenced the order on the stipulation and agreement in docket number 11 GBEE 624 COC?
Yes, I was.
Do you remember the restriction on cost recovery that we discussed at that time?
Yes.
Do you believe the testimony that I just questioned you about is consistent with that condition in that previous order?
Yes, I do.
No more questions. Thank you.
Grainbelt, do you have any cross-examination?
No questions.
All right, commissioner questions. Commissioner Keen.
Yes, thank you, Chair French. Good afternoon, Paul.
Good afternoon.
Welcome to the commission staff. We're glad you're here.
Thank you very much.
Whether you're glad with my questions, we'll find out. Were you here this morning when I cross-examined Mr. Chandler?
Yes, I was.
I want to cover some of the same territory with you. Number one, in the interest of the completeness of the record with respect to some of the issues I want you to address. And number two, I think really in fairness to the totality of the record and the company's application. Do you recall during my cross-examination of Mr. Chandler, in effect, we had a bit of a colloquy, if you will, about some of the protocols that were in place basically to see if I can describe this correctly, to set out certain commitments concerning the relationships that the company would have with the landowners and the dealings with the landowners. Do you recall that?
Yes, I do.
And then from that discussion and that issue, I turned to the question of the relationship between the company and the accommodations it was willing to make in terms of dealing with another land user besides the agricultural purposes, and that was, pardon me, the oil and gas industry. Do you recall that line of questioning?
Yes, I do.
I guess sort of implicit in the questions that I was asking of Mr. Chandler is my belief that both the landowners and the oil and gas lease operators are two very consequential users of the lands in the instances that are relevant here that may also be utilized by the company in constructing and operating its lines. Is that a fair statement? Would you agree with that?
Yes, I would agree with it.
I'm going to ask you a leading question now. In your opinion, would it be worthwhile for there to be in this circumstance a protocol that could set out as generally or explicitly or specifically as the circumstances may be necessary, a commitment to the development and management of ongoing relationships between the company and oil and gas operators? Or would there be any benefit, or would there be a detriment? Just give me your thoughts about that.
Yes, I do think there would be a benefit, and the landowner protocol was filed in this docket, and I think that it's really comprehensive and covers the agricultural aspect, but defining protocols in advance of these interactions, I think is better than running into problems later. So I think it would benefit or improve the landowner protocol if they expanded it to cover things beyond agriculture and potentially include gas and oil leases.
And I'm talking about really the oil and gas operations
Yeah.
On the surface, including storage facilities and other equipment that's being utilized on the land as well. Is that what you had in mind as well?
Yes, they'll have to cohabit the property per se in the future, so defining the protocols would be beneficial.
Yes. And I don't mean to be too provincial in advancing this thought, because I think we're talking about really consequential users, not only agricultural users, but this is another important and historic use in Kansas, is it not? The development, exploration, and production of oil and gas.
Yes.
It includes rights of ingress and egress and use, would it not?
Yes, similar to the agricultural purposes, I think it would follow the same principle.
I agree. I agree completely with you. I think there's an analogy here.
Right.
Really. Okay, thank you for that. My last series of questions here, and we'll be very brief, because I do want to draw out what I think is really your knowledge. We're guesstimating to a certain extent, because the questions I want to ask you now are about this national transmission corridor. We're in the early stages of that, in a sense. Unfortunately, one of the major points of input for the public in terms of a deadline is already passed. And now we find we're kind of in the midst of controversy. It may be the product of misinformation, but there's a lot of controversy about that. So let me beat in on that a little more specifically, realizing that the whole concept itself is transitional. We've got other phases to follow, the phases that we're in the process of working through right now. My first question would be, is the proposed grain belt project actually within the proposed corridor?
The AC collector lines, I think that the southwest part of the Meade line is in the southwest corridor, and then near the, I guess, endpoint of both lines, there's a little bit of overlap, but the AC collector lines, for the most part, are not in the preliminary corridors.
Those that are within the corridor, the former that you alluded to, I'm going to use a phrase. You can either agree with it or disagree with it, and please feel free to do that.
Okay.
Is it relatively de minimis?
Yes, it's relatively de minimis.
Okay. So my next question, again, it's the same question I posed to Mr. Chandler. It contains some conjectural and speculative elements to it. I grant you that. But given the fact that even a tangential or a small part of this line, one part of this line is within the corridor, I almost think it's unfair for me to ask the question, but in the interest of fairness to Mr. Chandler, I'm going to ask it anyway. Can FERC override any decision the KCC makes on line siting in this instance?
I'm not an expert on the NITI corridors. However, based on my understanding of them, in this circumstance, FERC wouldn't be able to override it. But it would depend on the outcome of this case as well, I would think, in terms of if the permit was denied, but at the same time, they're preliminary corridors and were, for the most part, not in the corridor. So in terms of the AC collector lines, I don't think that would come into play.
Let's say the permit were granted, but it were subject to certain conditions. What would be your view in that instance?
since it's outside of the corridor, I don't think that FERC would come into play. I do think there's a requirement that if you put conditions that impair the project, that then FERC can, if there is an approved corridor. So if all of those things occurred in a different circumstance in Kansas, then the NETCs could come into play.
But in the absence of something that draconian, probably not.
Right.
High level of probability not.
Right. I'd say it's more of a concern for future projects.
Okay. Very good. Thank you for your indulgence in my questions. I appreciate your testimony. That's all for me. Thank you.
Commissioner Keither, any questions? Good afternoon, Mr. Owings.
Thank you.
I think I'd just like to get your perspective on, the same questions I was kind of asking about. We've got this dispute between Sunflower and Grain Belt of whether the need for mitigating upgrades will be sufficiently studied within the SPP interconnection study process. And it does appear in the list of disputed issues that staff does not share Sunflower's concern, that staff seems to be satisfied that the studies, the interconnection studies that take place at SPP will be comprehensive enough. Is that a correct characterization?
Yes, it is correct. And it's kind of evolved throughout the docket. In my direct testimony on July 3rd, I had recommended that studies be complete to determine any potential power quality problems and those problems be mitigated in advance. And there was response to that. And I did clarify that we don't want to impose duplicative efforts on Grain Belt. If it's already being studied, then we don't necessarily want to impose duplicative efforts. However, at the same time, if at a later date the studies were found to be inadequate, I think it would be beneficial to know about it, and potential not maybe a condition of this docket itself, but then we could review that and consider it further and potentially do a show cause if it was imperative or some other mechanism to bring that up. But I think in principle, we were considering cost causation, and whoever causes the problem should pay for the problem. And we also wanted the problem to be studied. That way, any potential interference between the two systems would be determined ahead of time and mitigated rather than causing a problem.
So, as I've kind of learned today through Mr. Tamimi's testimony, the rub seems to be not that the studies won't take place, but they don't think that they don't have any firm assurance from Grain Belt or SPP, and Sunflower does not have any firm assurance that the scope of those studies will be broad enough. Is that something that staff discussed internally at all?
We didn't get into the exact scope of the SPP studies.
Okay.
But I think that's the dispute, really. I think everyone agrees that the problem should be studied, the power quality issue, and it should be mitigated. It's just a dispute over whether the SPP studies have adequate scope or need to be broadened, or additional detail needs to be provided to augment those studies.
And then on the other study, the mutual induction study that's being prepared outside of the SPP study, I think we heard testimony from the Grain Belt witness that if there are any upgrades required to mitigate issues as a result of that study, I think he very candidly said that they would expect those would be the responsibility of Grain Belt to pay for those, but also conceded that that's not necessarily memorialized anywhere. There isn't a contract that says who will pay for them. Does staff have any concern that that component is not memorialized somewhere? Does staff, I realize you've already stated your position and it's memorialized in your list of disputed issues, but is there any need for for the commission to memorialize that requirement that outcome of that study would be paid for by Grainbelt?
I think anytime you can define things in advance on how they would occur and memorialize them, it would be beneficial. I wasn't familiar with the induction study until today, so I guess it was news to me. However, I think if you can define how that will, follow the cost causation principle going forward, it would definitely simplify any disputes in the future and eliminate an ambiguity perhaps in the future, should that occur.
I appreciate that. I don't believe I have any more questions. Staff, any redirect?
No redirect.
All right, nobody needs recross?
Yeah, just briefly.
Go ahead.
With your indulgence, thank you.
Mr. Schulte.
Hi, Mr. Owings.
Hi.
In this case, have you reviewed a large quantity of feedback from landowners?
Yes.
And I believe in discovery, staff requested all of the comment cards that were received as part of Grainbelt's outreach before filing the application. Do you recall requesting and receiving those?
Yes, I do.
And I know that you participated in the open house prior to the local public hearing, as well as the question and answer session. Were you there?
Yes, I was.
As well. Okay. And in your experience, is the primary use that landowners are concerned about being impacted agricultural in nature?
Yes.
And Commissioner Keene indicated earlier that he was concerned about impact on oil and gas operations in general with transmission lines, but hadn't necessarily heard anything with regard to this line. Is that consistent with your experience working on this line?
Yes, it is.
Okay. I think that's all I had.
All right, any additional commissioner questions or redirect as a result of that? Commissioner Keene?
You made me do it, Andrew. Whether or not we've heard anecdotally that there's a concern about whether or not there'd be something on the order of a protocol, I'm generalizing now, for oil and gas operations, wouldn't it be in the ordinary course of all of these line setting dockets that are analogous to this one, that to set a tone of good faith between two really major users of the land, that it would be beneficial?
I think having, all the land uses in mind would be a best practice, and, trying to, I guess I realize you can't contemplate every single potential land use, but having those common land uses in mind would be beneficial and a good practice on projects such as this. And if it did come into play, then you would have your best practices outlined. And I'm thinking of the general investigation right now, and perhaps that's something we contemplate within that is what type of landowner protocols we would like to have in place.
Because after all, we're talking about consequential users, not incidental users, are we not?
Yes.
Thank you. Thank you.
Does staff have any redirect?
Just one clarifying redirect question. Mr. Owings, when you referred to the general investigation in your previous response, is that in reference to docket 24-2 GIME-102-GIE?
Yes, it is.
Okay, thank you. That's all.
All right, thank you. All right, if we have no additional recross or redirect, we will release the witness. Thank you for your testimony.
Thank
You may
you.
step down. All right. Are there any final concluding matters we need to address before we adjourn? Just a heads up to the parties, I think that the commission may have a few legal questions we want addressed in briefing. I'm not going to try to relay those right now. We will make sure the pre-hearing officer communicates with the parties within hopefully 1 to 2 days, hopefully by end of day today if we can. So you'll have those for briefing. As a reminder, the briefing schedule is as follows. Initial post-hearing briefs will be September 6th. And reply briefs September 13th. A commission order in this docket is due by September 30th, 2024. And if there are no further matters, we will close the record and adjourn. Thank you.